There is a particular sound my mother-in-law makes when she thinks she is won. It isn't a laugh. Not really. It's more like a small, satisfied exhale through her nose, followed by a smile that never quite reaches her eyes. I heard that sound in a Charleston County courtroom on a gray Tuesday in October, right after I signed my name on the last page of a settlement agreement that gave away the house my husband and I had built our whole life inside. Diane Whitfield sat 2 rows behind me in a cream-colored suit, her hands folded in her lap like she was at church, and when the pen left my fingers, she made that sound. She turned to her lawyer, Gerald Simmons, and said, "Just loud enough for me to hear." Well, that's that then. I want to tell you that I felt nothing in that moment, that I had already steeled myself against her, that some part of me was already 3 steps ahead. That would be a lie. What I felt was the floor of my life falling away beneath me, the same floor that had already fallen away once before, 7 months earlier, when a state trooper stood on my porch at 11 at night and asked if he could come inside. But grief, I have learned, does strange things to a person. It hollows you out, and then, if you let it, it fills that hollow space with something harder. Something that doesn't flinch. Something that can sit very still while a woman who has spent 4 years trying to erase you smiles like she's already picked out the curtains. Diane never read the settlement agreement past the paragraph that gave her what she wanted. She had her lawyer's summary, she had her own certainty, and certainty, in my experience, makes people lazy. She did not read Exhibit C. She did not ask what a Memorandum of Understanding recorded at Book 4471, page 209, actually meant, or why my lawyer had insisted, so calmly, so reasonably, that it be attached in full. She should have read it. But I'm getting ahead of myself. To understand why a woman could smile at another woman's ruin, and to understand why that smile didn't last, you have to go back to the beginning, to a rainy Tuesday 11 years ago, at a coffee shop in downtown Charleston, when I was 26 years old and had no idea that the man reading a paperback in the corner booth would one day be the reason I learned exactly how far his mother was willing to go, and exactly how far I was willing to go to stop her. My name is Claire Bennett. It was Claire Bennett for 26 years, Claire Whitfield for the 11 years after that, and these days I'm not entirely sure what to call myself, except that I know I'm the one still standing. I grew up in Mount Pleasant, just across the water from Charleston, the only daughter of a nurse and a man who fixed HVAC units for a living and believed, with the quiet conviction of someone who had never had much, that hard work was the only currency that mattered. We didn't have money. We had dinner at 6, church on Sunday, and a mother who told me, more than once, that a man's character showed up in how he treated people who could do nothing for him. I met Daniel Whitfield on a Tuesday in March, in a coffee shop on King Street called The Daily, during a rainstorm that had turned the gutters into rivers. I was 26, 3 years out of nursing school, working double shifts at MUSC, and I ducked into the coffee shop to wait out the worst of it. He was in the corner booth, hunched over a battered paperback of East of Eden, and when I dropped my umbrella trying to shake it out, he looked up and said, without any particular smoothness, "That book is exactly as good as everyone says it is, in case you're wondering." I wasn't wondering. I told him so. He laughed, a real laugh, surprised out of him, and asked if I wanted to sit down until the rain let up, since the only other open table had a view straight into the alley dumpster. He was 30 then, an architect 2 years into his own small firm, the kind of man who asked questions and then actually listened to the answers, which I would come to learn was rarer than I'd realized. We talked for 2 hours. He walked me to my car under his umbrella, which did nothing for either of us since the wind kept turning it inside out, and he asked for my number without an ounce of the performative confidence I'd grown used to from men my age. What I didn't know that day, and wouldn't fully understand for years was that Daniel had grown up in a house where love was conditional and admiration was currency, and that the boy who had once memorized his mother's moods the way sailors read weather had grown into a man who was, in his own way, still doing it. Diane Whitfield had raised her son to perform for her approval, and some quiet, unacknowledged part of Daniel had spent his whole life trying to find people who loved him without a transaction attached. I think that's part of why he loved me. I never once asked him for anything he didn't offer first. We dated for a year before he brought me to his parents' house on Sullivan's Island, a low country stunner with wraparound porches and a view of the harbor that probably could have paid off my nursing school loans twice over. I remember standing in the driveway, smoothing down a blue dress I'd bought specifically for the occasion, and Daniel squeezing my hand and saying, "Just be yourself. She'll come around." She did not come around. Not that day. And I understand now, not ever. Diane Whitfield opened the door before we even reached it, which I would later understand was a habit of hers, arriving one step ahead of everyone so that you were always walking into a room she had already arranged. She was 58 then, tall, elegant in the specific way of Southern women who have spent decades curating themselves like a piece of property. Hair the color of polished brass, a linen dress that had clearly never touched a washing machine, a smile that she deployed like a tool rather than an expression. "So this is Claire," she said, and the way she said my name made it sound like a fact she was still deciding whether to believe. Robert Whitfield, Daniel's father, was kinder from the first minute. A broad, sunburned man who had built a modest fortune in commercial real estate development and somehow retained the manners of someone who remembered what it was like to not have any money. He shook my hand with both of his and said, "Any woman who can put up with my son's terrible taste in neckties has my respect," which made Daniel groan and made me like Robert immediately. Dinner was excruciating in the way that only a certain kind of hospitality can be. Every course perfect. Every question from Diane engineered to locate exactly where I fit on some internal ledger she was keeping. Where had I gone to school? What did my father do? Did I intend to keep working once I settled down? I answered honestly because I didn't yet know that honesty, with Diane, was often mistaken for a weapon she could use later. "A nurse," she said, turning the word over like she was checking it for flaws. "That's very noble. Very hands-on work." "It is," I said. "I always thought Daniel would end up with someone a bit more." She paused, delicately, the way a surgeon pauses before the cut. "Established." Robert cleared his throat. "Diane." "I'm only saying she has time. Plenty of young women reinvent themselves." She smiled at me then, that same smile, tool, not expression. "No offense meant, dear." Offense was, of course, entirely the point. I would spend the next decade learning to recognize that particular sentence structure, "no offense meant, dear," as Diane's verbal equivalent of a hand grenade rolled gently across the table. In the car afterward, Daniel apologized 3 separate times before we reached the bridge back to Mount Pleasant. "She's not usually like that," he said, which I understood even then to be the kind of thing children say about parents they are still, on some level, afraid of. "She'll warm up." "Maybe," I said, though I already suspected otherwise, and I already knew it wouldn't change how I felt about him. I had decided, somewhere between the soup course and the excruciating dessert, that I loved Daniel Whitfield enough to survive his mother. I did not yet understand what surviving her would eventually cost. Daniel proposed 14 months later on the pier at Folly Beach, with a ring that had belonged to his grandmother, a detail Diane brought up so many times over the following months that I eventually understood it wasn't sentiment, it was inventory. "That ring is a Whitfield ring," she told me once, unprompted, apropos of nothing, while we set the table for Easter. As though I might try to make off with it. We married in April, at a garden venue outside Charleston that Daniel and I had chosen and paid for almost entirely ourselves, because Diane had made it clear, in the careful diplomatic language she used when she wanted something without asking for it, that she would prefer input if she were contributing meaningfully. And Daniel and I had quietly agreed that meant we would rather do it ourselves. That did not stop her from trying to run it anyway. She called my mother, not me, 3 weeks before the wedding to suggest, as a favor, that the color palette I'd chosen was a bit much for a woman your daughter's size. A sentence so strange and cutting that my mother, who does not anger easily, hung up the phone and didn't speak to Diane again until the rehearsal dinner. Robert, for his part, walked me part way down the aisle himself. Not officially. My father had that honor. But he met me at the top of the garden path before the processional, squeezed my hand, and said, "You make him steadier. I've watched it happen. Don't let anybody tell you that's not worth something." I have held on to that sentence for 11 years. I would need it, later, more than I could have imagined that day. Diane's toast at the reception was a masterwork of implication. She talked about Daniel's childhood, his ambitions, the important legacy of the Whitfield name, and mentioned me exactly twice. Once to note that I had found my way into the family, a phrase that made it sound like I'd wandered in through an unlocked door, and once to say she hoped I would grow into everything this family represents. My own mother, sitting at the head table, gripped my father's hand so hard he later showed me the marks. Daniel apologized again that night, in our hotel room, still in his tux, sitting on the edge of the bed with his tie loosened. I should have said something. During the toast. "You don't have to fight your mother's battles for me," I told him, which felt true and brave in the moment, and which I would come to regret, a little, in the years that followed. Because the truth was, I did need him to fight some of those battles, and he mostly didn't. Not because he didn't love me, but because some deeply buried part of him still flinched at the idea of his mother's disapproval, the way a hand flinches from a stove it was burned on as a child. "She'll come around," he said again, that familiar refrain, and I let myself believe it, because believing it was easier than the alternative, and because I was 27 and in love and hadn't yet learned that some people don't come around. Some people just wait. Robert Whitfield was, in almost every way that mattered, the opposite of his wife. Where Diane calculated, Robert simply liked people, liked hearing about my shifts at the hospital, liked asking Daniel about the buildings he was designing, liked, eventually, teaching my daughter Sophie to fish off the dock behind their house, patiently rebaiting her hook 40 times in an afternoon without a flicker of impatience. He was also, I would learn much later, the only person in that family who fully understood what his wife was capable of. About 2 years into our marriage, Robert called Daniel and asked him to come by the house alone. "No, Diane," he specified, which was itself unusual, since almost nothing happened in that family without Diane's oversight. Daniel came home from that visit quiet, thoughtful, and told me that his father had set up something called a generation-skipping trust, structured with the help of an estate attorney named Harold Voss, a man Robert had used for decades and trusted completely. "He wants to make sure Sophie and I, and you, are taken care of no matter what happens," Daniel told me, separately from Mom's side of things. I didn't think much of it at the time, if I'm honest. I was 30 then, a new mother, exhausted in the specific bone-deep way that only a colicky infant produces, and estate planning felt like a problem for people much older than us. Robert was healthy. Diane was, if anything, more energetic than either of us. It felt theoretical. What I understand now, looking back with the particular clarity that only comes after everything has already happened, is that Robert had watched his wife operate for 35 years of marriage, had watched the way she treated money as a leash rather than a resource, and had quietly decided that his son's family needed a wall between them and Diane's control, a wall built with paperwork, since it couldn't be built with conversation. He said something strange, Daniel told me that night, lying in the dark of our bedroom with Sophie's monitor crackling softly on the nightstand. He said, "I love your mother, but I've watched what she does when she thinks something belongs to her. Don't let her ever think this house, any house you buy, belongs to her." "What house?" I asked. "I don't know. I think he meant whatever we end up buying. He said the trust language would make sure of it, that anything purchased using those trust funds would be titled to me and you, outright, no strings, no reversion to the family estate. He had Harold draft something extra just in case, some kind of memorandum. He said it was insurance. I remember laughing a little at the time at the drama of it. Insurance. Against what exactly? Diane could be cutting, could be cold, could make a Thanksgiving dinner feel like a hostage negotiation, but I didn't yet understand her as a genuine threat. She was my mother-in-law, not a villain in a legal thriller. It would take years, and a great deal of loss, before I understood that Robert had not been dramatic at all. He had been exactly, precisely right. 3 years later, Robert Whitfield died of a heart attack in his workshop behind the Sullivan's Island house, a router still running on the table beside him, a half-finished birdhouse he'd been building for Sophie's 6th birthday, sitting in the vise. He was 66 years old, and with him died the only real check on Diane Whitfield's authority over that family, or so she believed, for a while, until she discovered, far too late, that he had left one small, quiet, devastating thing behind. Robert's funeral was held at St. Michael's downtown, under a sky so blue and cloudless it felt almost like an insult. 300 people came. Business partners, city councilmen, men Robert had built strip malls and office parks with over 4 decades, half the congregation of a church he'd attended twice a year. Diane stood at the front in black Chanel, receiving condolences like a queen accepting tribute, and I watched her, holding 4-year-old Sophie's hand, and felt something shift in the air of that family that I couldn't yet name. It was grief, certainly. I don't want to suggest Diane didn't grieve her husband. I believe, in her own particular way, she did. But grief in Diane was never a soft thing. It hardened into something else almost immediately, a kind of urgent, anxious need to consolidate, to know exactly what belonged to whom, to make sure nothing that was hers, or that she believed should be hers, slipped through her fingers the way her husband just had. 3 days after the funeral, before Robert was even in the ground a full week, Diane called Daniel and asked him to come to Harold Voss's office to review some paperwork. Daniel came home from that meeting paler than I'd seen him since we lost Robert. "She wants to restructure the trust," he told me, sitting at our kitchen table with his hands wrapped around a mug of coffee he wasn't drinking. "Restructure it how?" "She wants to be named sole trustee. Dad had Harold and a corporate trustee, a bank, as co-trustees. Some kind of check and balance thing. She wants that changed." Harold pushed back a little, but he rubbed his face. "She was Mom. You know how she gets." "What did you say?" I said I needed to think about it. He looked up at me. "Claire, the house. Our house. The one we're looking at on Trad Street. It's supposed to come out of the trust distribution. Dad set that up specifically. If she's sole trustee, she controls the timing of distributions. She controls a lot more than I realized. I want to be honest about something here, because this story only works if I'm honest. I did not fully grasp in that moment how serious a threat that represented. I was thinking about Sophie's preschool tuition, about a leaking dishwasher, about a night shift I had in 6 hours. Trust language felt like the concern of people with more time and more money than the amount of either I'd grown up believing existed. I told Daniel to trust his instincts, to talk to Harold privately if he was worried, and to try to get some sleep. He did talk to Harold privately, as it turned out. A conversation I wouldn't learn the full contents of for another 8 years. We closed on the house 11 weeks after Robert's funeral. A narrow, sun-faded single house on Trad Street in downtown Charleston, built in 1841, with a double piazza porch and heart pine floors that groaned in exactly the places you'd want floors to groan, in the way that makes an old house feel alive, rather than merely old. It needed work. The plumbing was original enough to be a genuine health hazard, and the kitchen had last been renovated sometime during the Ford administration. But Daniel walked through it during our first showing with the particular light in his eyes that I'd only otherwise seen when he was 3 drinks in at a wedding, dancing badly and completely without self-consciousness, and I knew before he said a word that this was the house. It cost more than either of us would ever have managed on a nurse's salary and an architect's, even with his firm doing well. The down payment, and a significant piece of the purchase price beyond it, came from a distribution out of Robert's trust, a distribution Daniel later told me Harold Voss had pushed through with unusual speed, before anything changes, in Harold's own words, which Daniel repeated to me with a slight frown, like he was only now understanding what they might have meant. The title went into both our names, Daniel and Claire Whitfield, tenants by the entirety, which our closing attorney explained meant that if anything happened to either of us, the surviving spouse would inherit the whole property automatically, outside of probate. I remember signing that closing paperwork in a bright conference room downtown, 8 months pregnant with our second child, feeling like the luckiest woman in Charleston. I did not read every page of every document that day. I want to say that clearly, because it matters to how this story unfolds, and because I think there's an important and uncomfortable truth buried in it. I trusted my husband, and I trusted Harold Voss, an old family friend who had known Daniel since he was in diapers, and I signed where I was told to sign, the way most people do, the way most people have always done, because reading 50 pages of legal boilerplate at 8 months pregnant with a 102-degree Charleston heat index outside felt like a luxury I did not have. I would think about that decision, that particular kind of trust, many times over the following decade. I would think about how easy it is to hand your future to people who love you, and how much harder it becomes to protect that future when the people who love you are gone, and the people left holding the paperwork love someone else more than they've ever loved you. There was one document in that stack, though. One page, tucked between the deed and the title insurance binder, that Harold Voss had specifically walked Daniel through, alone, in his office, the week before closing. Daniel told me about it briefly that night, the way you'd mentioned something odd and forgettable. Harold had me sign something extra, he said. A memorandum, recorded with the deed. He said it was to protect the trust's interest in case anything ever got, his word, contested. Contested by who? Daniel was quiet for a moment. He didn't say. I think he meant if Mom ever tried to claim the trust money used for the house should come back to the estate somehow. He said it confirms the property is fully, irrevocably, yours and mine, no matter what happens to the trust later. He said Dad had asked for something like this specifically, before he died. Some kind of, I don't know, ironclad language, recorded publicly so it can't just get quietly changed later. I nodded, filed it away in the enormous mental folder labeled Legal Things I Will Never Need to Think About Again, and went back to worrying about paint colors for the nursery. It is almost funny now, looking back, how many times life hands you the exact tool you'll need to survive something years before you understand what you'll be fighting. You just don't know to hold on to it tightly. You set it down in a drawer and forget it's there. Diane, notably, was never told the details of that memorandum. Harold Voss, it turns out, had strong opinions about client confidentiality, and stronger opinions, apparently, about Diane Whitfield. I want to tell you that the years between our closing on the Trad Street house and Daniel's death were simply happy, because in the ways that mattered most, they were. Noah was born 9 weeks after we closed, a furious, red-faced boy who grew into the gentlest child I've ever known. Sophie started kindergarten at a little magnet school downtown and came home reciting facts about horseshoe crabs with the fervor of a cult member. Daniel's firm landed a contract designing 3 boutique hotels along the Carolina coast, and for a while, on the surface, everything about our life looked exactly like the life I'd wanted since I was a girl, watching my parents count grocery coupons at the kitchen table. Underneath that surface, though, Diane never stopped working. It wasn't dramatic, most of the time. It was smaller than that, more insidious. The kind of thing that's genuinely hard to describe to someone who wasn't there, because any single instance sounds almost reasonable, almost like nothing. She would call Daniel, not me, to discuss family matters that concerned our household, effectively erasing me from decisions about my own children's college funds or holiday schedules. She would show up unannounced at the Trad Street house with a decorator, just to look, rearranging furniture in rooms I hadn't invited her into. She once had a landscaping crew show up on a Saturday morning to fix our garden, without asking, because, her words, relayed to me by an apologetic landscaper standing confused in my driveway, Mrs. Whitfield said the azaleas were an embarrassment to the block. At family dinners, she perfected a particular art of the backhanded compliment, delivered with a smile so warm that anyone watching from outside the marriage would have assumed we were close. "Claire's so devoted to her nursing," she'd say to guests, even though I always thought Daniel needed someone who could really run the social side of things. But I suppose we all have our roles. Or, "I don't know how she manages the children on that schedule. Some women just have more instinct for it than others, I suppose. But Claire tries so hard." Every sentence a small hook designed to catch and pull, and every sentence delivered with enough deniability that if I ever objected, I would be the one who sounded unreasonable. I raised it with Daniel more than once. He would sigh, rub the back of his neck, and say some version of the same thing he'd said for years. "That's just how she talks. She doesn't mean it the way it sounds." And I believed, for a long time, that he genuinely thought that he had grown up so thoroughly inside his mother's particular weather system that he had lost the ability to recognize it as weather at all. It was simply the climate. You don't notice the air you've always breathed. What I didn't fully appreciate, not then, was that Diane wasn't merely being difficult for its own sake. She was laying groundwork. Every comment about my instincts, every implication that I was somehow a temporary fixture in her son's life rather than a permanent one, every subtle reminder to Daniel and to anyone listening that the Whitfield name and the Whitfield money came with strings attached to Diane specifically. All of it was, I now understand, a slow-motion argument being built over years, an argument whose thesis was simple. Claire does not really belong here, and everything in this family, ultimately, belongs to me. She was building a case. She just hadn't found her courtroom yet. Daniel died on a Thursday in March, almost exactly 11 years after the rainy afternoon we met in that coffee shop on King Street. He was driving home from a site visit in Mount Pleasant, crossing the Ravenel Bridge a little after 9 at night, when a delivery truck driver who had been awake for 19 hours drifted across the center line. The impact was, according to the accident report I read only once and have never opened again, immediate and unsurvivable. He was 41 years old. I was folding laundry when the doorbell rang. Sophie was asleep. Noah had a fever and had finally, after an hour of rocking, gone down too, and I remember feeling almost lighthearted for a second, standing up from the couch, thinking Daniel must have forgotten his keys again, already smiling as I reached for the door. I have relived the walk from that couch to that door more times than I can count, trying to locate the exact moment when I still didn't know, when the world was still whole, so that I could stay there a little longer. There were 2 officers on the porch, a state trooper and a chaplain from the sheriff's office, which is how you know, before anyone says a word, that the news is the worst kind. I don't remember most of what they said. I remember the porch light attracting moths. I remember thinking, with a strange, useless clarity, that I needed to turn off the stove, even though nothing was on it. I remember calling my mother before I called Diane, and I remember, even in the very worst hour of my life, feeling a flicker of dread about making that second call. Diane arrived at the house 40 minutes later, and I will say this for her, because it's true, and because this story is only worth telling if I tell all of it honestly. Her grief that night was real. She stood in my front hallway and made a sound I had never heard a human being make before, something animal and broken, and I held her, both of us on the floor of the entryway. 2 women who had spent a decade circling each other now collapsed together in the exact same wreckage. For about 6 weeks after that, something almost like peace existed between us. Grief, for a while, flattened all the old architecture. She came by to help with the children. She sat with me at the funeral home while I chose a casket, her hand on my back, steady in a way I hadn't known she could be. I let myself believe, in the fog of those weeks, that maybe this shared devastation, would finally be the thing that softened whatever had always stood between us. I was wrong about that. I was wrong in a way that would cost me almost everything. Daniel's funeral filled St. Michael's twice over, an overflow crowd standing in the side aisles, a line of cars stretching 6 blocks from the church to the cemetery. I stood at the front in a black dress my mother had helped me pick out 3 days earlier, Sophie's small hand in mine, Noah asleep against my shoulder because 18-month-olds do not understand why their mothers won't stop crying, and I remember almost nothing of the service itself except the specific, unbearable weight of the closed casket, and the fact that I could not make myself look at it directly, the way you can't look directly at the sun. Diane sat in the front pew across the aisle from me, not beside me, across from me, a detail that seemed small at the time and that I understand now was a decision, made deliberately, by a woman who had already begun, even in the depths of her own grief, recalculating where the family's center of gravity should sit. The first real crack appeared 11 days after the funeral. At a lunch Diane insisted on hosting to talk about next steps, at her house on Sullivan's Island, the same wraparound porch house I'd walked into as a nervous 26-year-old more than a decade before. Her sister-in-law, Vanessa, Robert's younger sister, a sharp, thin woman who had never much liked me and had never bothered to hide it, was there too, which should have told me something before the conversation even started. "I've been thinking about the house," Diane said, over a salad none of us were eating. "The Trad Street house. It's far too much for you, alone, with 2 small children." "It's our house," I said. "Daniel's and mine. I'm not going anywhere." Of course. She said it the way she said most things she didn't mean. "I only mean, practically, all those stairs, that old plumbing. And the expense of it. Property taxes downtown are simply astronomical now, Claire. And I don't know what Daniel's firm's insurance situation looks like, or whether you have any real income beyond your nursing schedule, and I do worry." "We're fine," I said, though the truth was more complicated than that. Daniel's firm had a small key man policy that paid out enough to cover about 8 months of expenses. I hadn't yet had the emotional room to think past those 8 months. Vanessa cleared her throat delicately. "I think what Diane's trying to say," she offered in the tone of someone translating for a foreigner, "is that the house was purchased with trust funds, Robert's trust. And there might be some question about how that property should be handled, going forward, now that things have changed." I looked at Diane. Diane looked at her salad. "What question?" I said. Could there possibly be? None at all, I'm sure, Diane said, smiling that smile. I only think we should all sit down with Harold at some point, when you're ready, and just make sure everything's tidy. For your own protection, dear. Estates get complicated. I'd hate for you to be caught off guard by anything. I left that lunch with a knot in my stomach that would not fully leave for the next 8 months, and that has, if I'm honest, never entirely gone away, even now. I did not yet understand what she meant by tidy. I would understand it fully, and in devastating detail, 4 months later, when Gerald Simmons filed a petition in Charleston County Probate Court on Diane Whitfield's behalf, arguing that the Trad Street property was never fully, legally removed from the Whitfield Family Trust, and that, as the trust's sole surviving trustee, Diane had both the right and the responsibility to bring it back under trust control for the benefit, the petition claimed, of the minor beneficiaries, meaning my own children, who Diane suddenly, conveniently, claimed to be trying to protect from their own mother. The papers arrived by certified mail on a Tuesday in July, 4 months and change after Daniel's death, while I was still, most days, forgetting he was gone for the first 3 or 4 seconds after I woke up, before the knowledge crashed back down like it did every single morning. Noah had just turned 2. Sophie had started asking, with the terrible directness of a 7-year-old, whether Daddy could see her from heaven, and whether heaven had a good view of our street. I opened the envelope standing in my own kitchen, the same kitchen where Daniel had told me, years earlier, about a memorandum I'd already half forgotten, and I read the words, "In re, the Whitfield Family Trust, petition for turnover of trust property," so many times that they stopped meaning anything, the way any sentence does if you stare at it long enough. The petition, when I finally made myself understand it, argued 3 things. First, that the funds used to purchase the Trad Street house had come directly from a trust distribution that was, according to Diane's reading of the trust document, meant to be a loan to Daniel and me, not an outright gift. A loan that, upon Daniel's death, became due and payable to the trust, secured by the property itself. Second, that because I had no independent legal claim to those original trust funds, and because the loan had never been formally repaid, the trust retained an equitable interest in the house sufficient to force its sale or transfer. Third, and this was the part that frightened me most, the part I read at 11 at night with my hands shaking so badly I had to set the papers down twice, that Diane, as trustee, believed the proceeds from the house should be held, for the benefit of Sophie and Noah Whitfield, in a trust account she alone would control, rather than remaining, as she put it, an unsupervised asset in the sole hands of a surviving spouse with no direct blood relationship to the Whitfield family line. No direct blood relationship. 11 years of marriage, 2 children, a decade of Thanksgivings and christenings, and holding her hand on the floor of my own front hallway the night her son died, reduced, in a legal filing, to the phrase, "no direct blood relationship." I called Daniel's old friend and college roommate, a defense attorney named Marcus Webb, who didn't practice trust law, but who at least knew which questions to ask, and Marcus, after reading the petition twice, told me something I have never forgotten. "This isn't really about the money," he said. "Well, it is about the money, but it's not only about the money. She's trying to make a legal argument that you were never really family. That's what this is underneath everything else." I hired a probate attorney the following week, a competent-seeming, if unremarkable, local lawyer named Preston Hale, recommended to me by a colleague at the hospital who'd used him for her own divorce. I want to be honest about something else here too, something that still embarrasses me. I hired him because he was affordable, because I was suddenly and acutely aware of how thin our finances actually were without Daniel's income, and because I did not yet understand that in a fight against Diane Whitfield, affordable, and competent was not remotely the same thing as sufficient. I would learn that difference the hard way over the following 10 months, in a courtroom, in front of a judge, with Diane sitting 2 rows behind me, making a sound like a small, satisfied exhale through her nose. What I did not understand, going into that fight, is that a legal battle against someone with Diane's resources isn't a single confrontation. It's an attrition campaign, fought across a dozen small skirmishes, most of which are designed less to win any particular point than to exhaust the person on the other side until she simply stops being able to fight. Gerald Simmons filed motion after motion, a motion to compel financial disclosure of every account I held, joint or individual. A motion to appoint a guardian ad litem to represent the interests of the minor children, which meant a stranger, paid $400 an hour, would now be interviewing my 7-year-old about her home life. A motion requesting a forensic accounting of the trust distribution used to purchase the house, going back 11 years, which meant Preston Hale needed weeks of paralegal time just to respond. Time I was billed for at rates that made my stomach hurt every time an invoice arrived. Diane, meanwhile, waged a parallel campaign outside the courtroom that was, in some ways, more effective than anything her lawyer filed. She called mutual friends, longtime members of the church, other mothers from Sophie's school, and delivered, in her warm, concerned voice, a version of events in which she was a grieving grandmother, simply trying to protect her grandchildren's inheritance from a daughter-in-law who had always been a bit financially reckless and who was clearly struggling since Daniel's death. I started noticing the change in how people looked at me at school pickup. A few longtime friends grew quietly distant. One woman I'd known for 8 years actually asked me, with what she probably believed was gentle concern, whether it was true I'd run through most of the life insurance already. I had not run through anything. I was working 3 12-hour shifts a week, paying a mortgage and daycare and a lawyer, and lying awake most nights doing math that never quite balanced. Vanessa, Diane's sister-in-law, took to bringing casseroles to the house to check on the children, visits that always seemed to coincide with moments when she could get Sophie alone for 10 minutes, asking careful, leading questions dressed up as innocent curiosity. Does Mommy seem sad a lot? Does Mommy ever raise her voice? Does Mommy talk about money? Questions a 7-year-old repeated back to me, confused, at bedtime, having no idea she'd just been debriefed. I brought this to Preston Hale, furious, wanting to file something, anything, to make it stop. He sighed in the particular way lawyers sigh when they're about to disappoint you gently. "We could file a motion," he said, "but honestly, Claire, judges don't love these he said she said family disputes cluttering up a probate docket. I'd rather save our capital for the real fight, the trust interpretation issue. That's where this actually gets decided." I didn't know yet that saving capital was a phrase I would come to distrust deeply. I didn't know that Preston Hale, for all his competence on paper, had a habit, one I would only fully understand months later, of consistently advising the path of least resistance, the settlement over the fight, the quiet resolution over the aggressive defense, because quiet resolutions were faster, and faster meant fewer hours logged against a client whose ability to pay he had, correctly, assessed as limited. I was, in other words, exactly the kind of client a certain type of lawyer settles rather than defends. And Diane, I would later learn, had understood this about my situation long before I did. I mentioned earlier that Gerald Simmons filed a motion to appoint a guardian ad litem to represent Sophie and Noah's interests during the litigation, and I want to go back and describe what that process actually felt like, because I think it deserves more than the passing mention I gave it, and because it remains, even now, one of the more surreal and frightening stretches of that entire ordeal. The guardian ad litem assigned to the case was a family law attorney named Denise Okafor, appointed by Judge Hall to conduct an independent investigation into the best interests of the minor children. A phrase that sounds, on paper, entirely reasonable, and that felt, in practice, like having a stranger with a legal pad walk through the most private rooms of my life and my children's lives, asking questions I had no ability to prepare for or control. Denise came to the house twice over the course of 6 weeks. The first visit, she spoke with me alone for almost 2 hours, asking about my work schedule, my support network, my finances, my relationship with Diane, my grief, my parenting philosophy. Questions that ranged from entirely reasonable to invasive in ways that left me feeling, afterward, strangely exposed, as though I'd been examined for flaws I hadn't known I was supposed to be hiding. The second visit, she asked to speak with Sophie alone, in Sophie's room, for about 40 minutes, while I sat in the kitchen unable to concentrate on anything, listening to the muffled cadence of their conversation through the wall without being able to make out actual words, feeling the specific helplessness of a mother who cannot protect her child from a conversation the law has determined she is not allowed to be present for. Sophie came out of that room afterward looking thoughtful rather than upset, which was, I think, more Denise's skill than anything else. She had apparently a genuine talent for making an intimidating process feel almost like a game to an 8-year-old, asking Sophie to draw pictures of her family, to describe a normal Tuesday from morning to night, to talk about what made her feel safe and what made her feel worried. Sophie told me later, unprompted. She asked if Grandma Diane ever scared me. I said no. She asked if you ever seemed too tired to take care of us. I said sometimes you're tired, but you always still take care of us. Is that the right answer? I told her there wasn't a right answer, only an honest one, and that she'd given exactly that. Denise's final report to the court, filed 3 weeks before the settlement was reached, recommended in careful, measured language that the children remain in my primary custody with no restrictions, that my parenting presented no identifiable risk factors, and that, this line, when Monica read it to me over the phone, made me cry harder than almost anything else in that entire process. The children appear securely and consistently attached to their mother, who has provided stable, attentive care through an exceptionally difficult period of grief and family conflict. That report never had to be used in any contested hearing, because the settlement resolved the guardian ad litem proceeding by mutual agreement before it ever reached that stage. But I have kept a copy of it, filed away in the same fireproof box as Robert's letter, because it remains, to this day, the single piece of documentation from that entire ordeal that I return to on the hardest days. Not the memorandum, not the settlement, not even Robert's letter, but a stranger's careful, independent confirmation that whatever else was happening around me, whatever else Diane believed about my fitness as a mother, I was, in fact, doing exactly what I was supposed to be doing for my children the entire time. There was a dinner, about 5 months into the litigation, that I have avoided describing until now because it remains, even years later, difficult to revisit fully. Diane invited the whole family, myself included, which surprised me, to Easter dinner at the Sullivan's Island house, a tradition Robert had loved and that Diane had continued, somewhat rigidly, every year since his death, regardless of whatever else was happening between us. I almost didn't go. Monica advised against it, initially, worried about exactly the kind of ambush it turned out to be. But Sophie had asked about it specifically, missing the tradition, missing the enormous Easter egg hunt Robert used to organize across the property's sprawling lawn before he died, and I decided, against my better judgment, that denying my children one more piece of normalcy in an already upended year felt like a cost I wasn't willing to pay, regardless of the risk to myself. Diane was, for the first 2 hours, disarmingly pleasant, warm with the children, gracious with my own parents, who'd come along for support, attentive in a way that almost made me wonder if Vanessa's earlier warnings about trust fund questions had been overblown after all. It was during dessert, with both children out of earshot in the yard chasing the last of the hidden eggs, that she leaned across the table and said, conversationally, as though remarking on the weather, "I do hope you're thinking realistically about your options here, Claire. A house that size is a great deal of upkeep for a single income. There's no shame in accepting help, you know, if you'd only stop being so proud about it." "I'm not being proud," I said. "I'm being clear that it's my house." "It's a house Daniel's father's money paid for," she said, still pleasant, still smiling, the specific pleasantness that had by then come to feel more threatening to me than any raised voice ever could. "I only think it's time someone in this family started being honest about that, instead of letting sentiment cloud what's actually fair to everyone, including those children out there right now looking for eggs." My mother, sitting beside me, set down her fork with a small, deliberate click. "Diane," she said in a tone I'd rarely heard her use, "I've sat through a great deal from you over the years, out of respect for my daughter's marriage and now out of respect for her grief. But I want to be very clear with you. If you say one more word implying that woman doesn't deserve her own home, I am going to say something in front of your entire family that neither of us will be able to take back afterward." Diane, to her credit, did not push further that night, though the tension at the table remained thick enough that I made an excuse to leave less than 20 minutes later, gathering the children under the pretense of an early bedtime, driving home across the bridge with my hands shaking on the wheel the entire way. I remember thinking, that night, that I could not survive years of this. Years of pleasant, smiling ambushes disguised as family tradition. Years of watching my own children's Easter egg hunts turned into staging grounds for financial intimidation. I did not yet know, that night, that I wouldn't have to. I just knew, driving home, that something in me had hardened past the point of return, and that whatever came next, I was no longer willing to simply absorb it quietly for the sake of keeping the peace. I want to spend a little time on something the drama of courtrooms and legal memoranda can make easy to forget. For almost all of that year and a half, I was still working full-time as a charge nurse in the cardiac step-down unit at MUSC, still pulling 12-hour shifts 3 or 4 times a week. Still coming home to 2 children who needed dinner and homework help and baths and bedtime stories, entirely independent of whatever was happening in probate court. There is a particular exhaustion to fighting a legal battle for your family's future, while also, simultaneously, holding down the ordinary machinery of an actual life, and I don't think I've adequately conveyed in the telling so far just how much of that period was simply grinding, unglamorous survival rather than dramatic confrontation. Most days did not involve courtroom hearings or discoveries of hidden memoranda. Most days involved waking at 5:30, getting Sophie to school and Noah to daycare, working a 12-hour shift where actual human lives depended on my full attention, regardless of what was happening in my own, picking the children up, making dinner, answering a lawyer's email at 10 at night after both kids were finally asleep, and doing it all again the next day. My colleagues at the hospital became, in their own way, as important to my survival as Monica was, even though none of them had any specialized legal knowledge to offer. Riva Patel, a fellow charge nurse who'd been widowed herself at 34, covered shifts for me without being asked whenever a hearing date landed on a scheduled workday. My unit manager, a gruff, kind man named Tom Bilecki, quietly adjusted my schedule for months without ever making me feel like a burden for needing it. I think often about how much harder this entire fight would have been without the ordinary, unglamorous kindness of people who had absolutely nothing to gain from helping me, and everything to lose in terms of their own time and energy by doing it anyway. I share this not because it changes the shape of the larger story, but because I think stories like this one risk implying that survival is mostly a matter of finding the right lawyer, the right document, the right dramatic reversal in a courtroom. Sometimes it is. But underneath every dramatic reversal in my own story was a much less cinematic foundation. A shift covered here, a casserole dropped off there, a coworker who noticed I hadn't eaten lunch and quietly put a sandwich in front of me without comment. That foundation doesn't make it into most retellings of stories like this, and I wanted, at least once, to make sure it made it into mine. I met Monica Reyes at a spin class, of all places, 6 weeks into the lawsuit, back when I still occasionally left the house for anything other than work or lawyer meetings. Because a friend from the hospital had dragged me there under the theory that endorphins fix everything, which they do not. But the class did at least give me 45 minutes a week where I wasn't thinking about trust litigation. Monica was 34, sharp-featured, with the specific energy of someone who ran on 4 hours of sleep and enormous quantities of black coffee. And she introduced herself after class by asking bluntly, "Are you okay? You've been staring at the wall during warm-up for 3 weeks like it personally wronged you." I laughed for the first time in what felt like months and told her, in the abbreviated version I'd started giving people, that I'd lost my husband and was now fighting his mother in court over my house. Monica's eyebrows went up. "What kind of fight?" "Trust litigation, probate court. My mother-in-law claims the house was bought with trust money that has to come back to the estate." "Who's your attorney?" I told her. She made a small, involuntary face, the kind of face a surgeon might make if you told her which doctor was operating on you next week, and said carefully, "Preston's fine for a straightforward estate. Is this straightforward?" "I don't think so." "What's your mother-in-law's lawyer's name?" "Gerald Simmons." Monica went very still. "Gerald Simmons," she repeated, and there was something in her voice, recognition, and not the warm kind. "I did a rotation at a firm downtown that went up against Simmons twice. He's good at exactly one thing, and it's not law. He's good at making the other side feel like settling is the only reasonable option, whether or not it actually is." It turned out Monica Reyes was not merely a woman with strong opinions about my legal representation. She was a real estate and trusts attorney herself, 4 years out of a fellowship at a firm in Columbia, currently working at a smaller downtown practice while she built her own client base. She had grown up, as it happened, 3 streets over from the Trad Street house, and had spent her childhood riding her bike past the very building I now lived in, a coincidence she found, when I told her, almost eerie. "I'm not trying to poach a client from a colleague," she told me, over coffee 2 weeks later, after I'd finally, hesitantly, asked if she'd be willing to look at my file. "But I want to see the petition, and I want to see the closing documents from when you bought the house. All of them. Every page." "Why the closing documents?" "The petition's about the trust language." "Because," Monica said, "petitions like this live and die on what actually got recorded at the time of purchase, not just on what the trust document says in the abstract. If there's language in your closing file that speaks to how that money was characterized, gift versus loan, outright transfer versus conditional distribution, that could matter more than anything Gerald Simmons argues about trust interpretation in the abstract. People forget to check the closing file. It's boring. Nobody reads it twice." I did not, at that point, remember the specific conversation Daniel had had with me about a memorandum recorded alongside our deed. It had been 8 years. I remembered vague shapes of it. Harold Voss, something about insurance, Daniel's slightly unusual seriousness that one night, but not the substance, not enough to mention it to Monica directly. What I did have, tucked in a fireproof box in our bedroom closet, was the full closing binder from the Trad Street purchase, unopened in years, exactly as thick and intimidating as I remembered it being on the day I signed it 8 months pregnant in a downtown conference room. I brought it to Monica the following Saturday. She read it at her kitchen table for 3 hours while I sat across from her drinking too much coffee and trying not to hover. And about 2 hours and 40 minutes in, she looked up at me with an expression I will remember for the rest of my life. The specific look of someone who has just found something they weren't sure existed and is trying very hard not to celebrate too early. "Claire," she said, "did you know there's a recorded memorandum attached to your deed? Separate document, recorded the same day. Book 4471, page 209. I did remember it then. A flash of that kitchen table conversation with Daniel, years earlier. Vaguely, Daniel mentioned something like that once. Something Harold Voss had him sign. He said it was to protect the property from ever being pulled back into the estate. Monica turned the document around so I could read it myself. It was 2 pages, dense with the kind of legal language that makes your eyes slide off the page if you're not specifically trained to hold your focus on it. But Monica walked me through it, line by line. The memorandum, drafted and executed by Harold Voss on Robert Whitfield's explicit instruction, a fact confirmed by a cover letter clipped behind it, addressed to Daniel and Claire Whitfield, which I had apparently never actually read 8 years earlier, in the exhausted blur of closing on a house 8 months pregnant, stated, in language Monica said was about as unambiguous as trust and estate law ever gets, that any and all funds distributed from the Whitfield Family Trust for the purpose of acquiring real property for Daniel Whitfield and his spouse were outright unconditional gifts, not loans, advances, or distributions subject to repayment, recoupment, or reversion of any kind, and that no trustee, current or future, shall assert any claim, lien, equitable interest, or right of turnover against any such property on the basis of the source of its acquisition funds. It went further. It specifically anticipated, in a clause Monica read aloud twice, the exact scenario now unfolding in court. This memorandum is intended to survive any change in trusteeship, including the appointment of a sole trustee, and to bind all successor trustees regardless of familial relationship to the grantor or to the beneficiaries named herein. He knew, I said, staring at the page. Robert knew this exact thing might happen someday. He didn't just suspect it, Monica said quietly. Claire, this reads like a man who sat down with his lawyer and said specifically, "My wife is going to try this someday. Write something that stops her cold." This isn't generic estate boilerplate. Somebody wrote this to defeat this exact petition years before the petition existed. I felt something complicated in that moment. Grief, mostly. A fresh wave of missing a father-in-law who had quietly, invisibly, tried to protect me from beyond the grave, but also something else, something sharper, that I didn't fully have a name for yet. It would take a few more weeks before that feeling crystallized into what it actually was. The first real flicker of the fight I would eventually bring to that courtroom. So this ends it, I said. We show this to Preston, he files it, the petition falls apart. Monica was quiet for a moment, and I could see her doing the specific mental math that lawyers do, not just what a document says, but how a document performs in front of a particular judge, against a particular opponent, inside a particular procedural posture. It should, she said carefully. In a clean world, this ends it in about a week. But I want you to think about something. Gerald Simmons doesn't know this document exists. Robert had Harold keep it out of Diane's file specifically. Your closing attorney recorded it independently, rather than routing it through the trust's counsel, which tells me Harold was being deliberately careful about who saw it. The moment you show this to Preston and Preston files it, Simmons will see it. Diane will see it. And they are not going to just fold. They're going to look for every possible way to attack its validity. Claim Robert lacked capacity when he signed the authorizing letter. Claim Harold exceeded his authority. Claim the memorandum itself is ambiguous. drag this out for another year in appeals while you bleed money on legal fees. Sometimes the strongest card in your hand is worth more face down. What are you suggesting? I'm suggesting, Monica said, that before we play this card, we think very carefully about how and when we play it. Because there might be a way to play it that doesn't just win. There's a way to play it that makes it impossible for them to ever come back at you again. I didn't fully understand what she meant that night. I would understand it 4 months later, in a courtroom, watching Diane Whitfield exhale through her nose in triumph over a piece of paper she had never bothered to read. I brought the memorandum to Preston Hale the following Monday, expecting relief. Maybe even a small note of professional embarrassment that he hadn't found it himself. What I got instead was a strange, deflating kind of caution that I didn't understand at the time and would only fully make sense of much later. "This is interesting," he said, turning the pages over slowly. "It could help. But Claire, I want to manage your expectations here. Documents like this get contested all the time in probate court. Simmons is going to argue Robert wasn't competent, or that Harold overstepped his authority as trust counsel by drafting something contrary to the trust's other terms, or a dozen other angles. Judge Hall doesn't love these fights turning into 3-year appellate odysseys. My honest advice, given everything, the cost you're already carrying, the toll this is taking on you and the kids, is that we use this as leverage in a settlement conversation, not as a silver bullet in trial. Get you a clean resolution. Something certain, instead of something theoretically stronger but years away." I look back on that conversation now and feel a complicated mixture of anger and something closer to pity, because I don't actually believe Preston Hale was corrupt, not in the cartoonish sense. I believe he was tired, overextended, managing a caseload that didn't leave room for a genuine fight against a well-funded opponent, and I believe, this part I do believe, with real conviction, based on things Monica later helped me piece together, that Gerald Simmons had made a specific, informal approach to him weeks earlier, floating a settlement framework, in the spirit of avoiding a costly and painful trial for everyone, language that sounds compassionate and functions, in practice, as a lever against an attorney who is already looking for the exit. "What would a settlement even look like?" I asked. "Diane's team has floated something," Preston said. "You'd transfer title of the Trad Street property into the trust, formally resolving the turnover claim. In exchange, she'd drop the guardian ad litem proceeding, drop the financial disclosure demands, and agree to fund a modest trust account for Sophie and Noah's education, separate from the house issue, that she'd control as trustee until they're 18. It ends the litigation. It ends the exposure of your finances. It ends Vanessa showing up at your door with casseroles and leading questions. It also means I lose my house." "It does," Preston said. "I won't pretend otherwise. But Claire, I've watched a lot of these fights. The people with more money win the war of attrition almost every time, regardless of who's actually right on the law. I think you need to consider whether staying in this fight another year, another 2 years, spending money you don't have, is actually worth it, when there's a settlement on the table that gets your children provided for and gets your life back." I left his office that day feeling something I hadn't let myself feel since Daniel died. Genuine despair, the kind that makes you sit in your car in a parking garage for 20 minutes because you're not confident you can drive safely yet. I called Monica from that parking garage, crying so hard she could barely understand me at first, and when I finally got the words out, "Preston thinks I should settle. Preston thinks I should just give her the house." Monica went quiet for a long moment. "Claire," she said finally, "I need you to trust me on something, and I need you to not tell Preston, not yet. And I need you to not tell anyone in Daniel's family, and I need you to be able to sit across from Diane Whitfield and look defeated even when you're not, because I think I finally understand the play here, and it's going to require you to be a better actress than you've ever been in your life. Monica's plan, when she finally laid it out for me in full over a bottle of wine we barely touched at her apartment, was elegant in the specific cold way that good legal strategy often is. A plan built not around avoiding Diane's victory, but around letting Diane win the exact victory she wanted, while ensuring that victory contained, inside itself, the seeds of its own destruction. Here's what I've learned about Gerald Simmons in the 6 years I've watched him work, Monica said. He is exceptional at pressure. He is mediocre at diligence. He wins cases by making the other side exhausted enough to sign whatever's put in front of them, and he wins settlements by drafting agreements that get skimmed, not read by his own client included. Diane doesn't actually read documents closely. I've heard this from 2 other attorneys who've dealt with her directly. She reads summaries. She reads the parts that confirm what she already believes. That's her real vulnerability, more than any legal argument you could ever make in front of Judge Hall. So what do? We let Preston negotiate the settlement framework because switching lawyers now would spook Simmons and slow things down. And honestly, Preston's fine at the transactional parts, even if he's weak on strategy. We let the broad strokes be exactly what Diane wants. Title of the house transfers, on paper, to the Whitfield Family Trust, resolving the turnover petition entirely, just like she's asking. Diane gets to stand up in that courtroom and watch you sign it. She gets her victory. She gets to feel, for however long it lasts, like she finally put you in your place. And then what? And then, Monica said, we make sure that the settlement agreement, as drafted, expressly incorporates by reference the recorded memorandum, Exhibit C, we'll call it, as the controlling instrument that defines the trust's continuing rights, or lack thereof, with respect to the property. It'll read, on its face, like standard boilerplate. Something like, the parties acknowledge the existence of certain recorded instruments affecting title, attached hereto as Exhibit C, which shall remain in full force and effect. Nobody skimming a 40-page settlement agreement stops to interrogate a sentence like that. It sounds like nothing. It sounds like the kind of clause every real estate lawyer includes reflexively. I was starting to understand, slowly, the shape of what she meant, but not yet the mechanics. But if the memorandum says the property can never revert to the trust, if it's ironclad like you said, how does Diane's team not catch that this settlement doesn't actually give her what she thinks it gives her? Because, Monica said, and here her voice had the particular quiet intensity of someone laying out a chess move 6 turns ahead. The settlement agreement will also include a formal deed transferring the property from you, individually, into the trust. The exact document Diane's side wants. The thing that lets her stand up in court and declare victory. What that deed cannot do, no matter how it's worded, is override a memorandum specifically drafted, executed, and recorded years earlier, at the direction of the person who created and funded the trust in the first place, stating in unambiguous language that the trust has no claim to that property at all. A later deed doesn't erase an earlier recorded restriction on the underlying trust's authority. It can't grant the trust an interest the trust was never legally capable of holding to begin with. When Diane's team goes to actually record that new deed at the Register of Deeds office, or attempts to assert any control over the property afterward, the title company, or any subsequent buyer's attorney, or frankly, any competent judge if it ever gets challenged again, is going to look at Book 4471, page 209, and conclude that the transfer into the trust was void from the moment it was signed, because the trust legally lacked the power to hold that property, full stop, no matter what the deed says otherwise on its face. I sat with that for a long moment, feeling something between hope and vertigo. So I sign away the house in court. Diane gets to celebrate, and then it just comes back? It doesn't come back, Monica said. It never actually leaves. That's the entire point. On paper, in that courtroom, on that day, it will look exactly like your worst fear coming true. And underneath that paper, nothing real will have moved at all, except that this time, it'll be recorded, litigated, and settled in a way that makes it essentially impossible for her to ever try this again, because a settlement agreement carries the force of a court order, and violating a court order carries consequences that a probate petition alone never did. Why didn't we just file the memorandum on its own? Fight this straightforwardly, from the start? Monica smiled, a small, sharp thing. We might still need to. This isn't without risk. If Simmons is more careful than I think, or if Judge Hall asks the wrong question at the wrong moment, this could unravel, and we'd need a backup plan, which we'll have. But if this works the way I think it will, you don't just keep your house. Diane files a sworn petition asserting she holds trustee authority to bring that property back under trust control. If it turns out that authority never existed, that she petitioned a court, under oath, for control over an asset the trust document itself says she has no claim to, that's not just a losing legal argument anymore, Claire. Depending on what else comes out in that process, that starts to look like something a probate judge takes very seriously indeed. That's the difference between winning a property dispute and making sure a woman like Diane Whitfield never gets to do this to you, or to anyone else, again. The next 4 months were, without question, the strangest of my life, because they required me to perform a version of defeat I did not feel, in front of an audience that included my own children's grandmother, at the exact moment I was closer than I'd been in a year to something that finally resembled hope. Monica coached me carefully. Don't overplay it, she told me more than once. Diane's instincts are sharp about performance, even if her instincts about documents are terrible. If you suddenly seem calm or worse, confident, she'll smell something. You need to actually let yourself feel some of this, Claire, because some of it is real. You are losing your house, as far as you know. Let that be true in your body, even while you know, somewhere quieter, that it isn't the whole truth. That distinction, letting something be true in my body while knowing it wasn't the whole truth, became, strangely, one of the more useful pieces of guidance anyone gave me that entire year, in ways that extended far beyond the courtroom. I have thought about it often since, in completely unrelated moments of my life. Grief works the same way, I've come to believe. You can let a feeling be entirely true in your body without it being the last or only truth available to you. I told Preston Hale in a phone call I still feel a small twist of guilt about, that I had thought it over and was ready to explore the settlement framework. I did not tell him about the memorandum's role in the final draft. Monica had by then quietly begun consulting informally with Preston's office on the closing and title aspects of the settlement, a common enough arrangement that Simmons's side never questioned it, framed simply as Preston bringing in a real estate specialist to make sure the property transfer language was clean and enforceable. Monica drafted the critical language herself, embedded 3 layers deep in an exhibit list, and Preston, genuinely relieved that his client was finally being reasonable, signed off on the draft without the kind of granular scrutiny he might have applied if he'd known what was actually writing on those specific sentences. Diane, for her part, grew visibly warmer toward me during those months, in the specific unsettling way that people grow warmer toward those they believe they've already beaten. She called to ask how the children were doing. She sent a card when Noah had his tonsils out. She mentioned, twice, almost gently, that she hoped, once this unpleasantness is behind us, we can go back to being a real family. A sentence that would have once made me want to scream, and that now, knowing what I knew, I received with something close to pity. Vanessa stopped coming by with casseroles. The guardian ad litem proceeding was quietly dropped, per the emerging settlement framework, 3 weeks before the hearing. Gerald Simmons sent Preston a draft agreement that ran 42 pages, most of it dense procedural boilerplate that Monica read 4 separate times, hunting for any sign that Simmons's office had noticed the true function of Exhibit C. They never did. The hearing was scheduled for a Tuesday morning in October, 10 days shy of the 1-year anniversary of Daniel's death, a scheduling coincidence that felt, at the time, like the universe twisting a knife it had already used plenty. I did not sleep the night before, not really. I lay in the bed I used to share with my husband, in the house I was about to pretend to lose, listening to the old heart pine floors settle the way they always did after midnight, that particular creaking language old houses speak to the people who love them. Sophie, who was 8 by then, had picked up on more of the tension in the house than I'd wanted her to, the way children always do, no matter how carefully you try to shield them. She'd asked me, 3 days earlier, brushing her teeth before bed, whether we were going to have to move. I told her the truth as best I understood it to be true for her, that there were some grown-up problems being sorted out, that whatever happened, she and Noah would always have a safe place to live, that I loved her more than anything else in the world, and that was the only fact she needed to hold on to. She nodded, spat, and said, with the terrifying directness of an 8-year-old, "Grandma Diane makes you sad. I've noticed." I did not correct her. Monica came by around 9 that night, ostensibly to drop off a folder of documents I'd need the next morning, but really, I think, to make sure I was going to be okay. We sat on the front porch. My porch. Our porch. The one Daniel and I had spent a whole spring restoring the railings on, sanding and painting in the evenings after Sophie went to bed. And she went over the plan one more time, slowly, patiently, the way you'd walk someone through directions to a place they were terrified of getting lost on the way to. "Tomorrow's going to feel unbearable," she told me. "I want you to know that going in, so it doesn't surprise you, you're going to sign documents that say, in black and white, that you're giving up your house. Diane is going to look triumphant. Simmons is going to look pleased with himself. Judge Hall is going to approve the settlement in about 4 minutes, because that's what judges do with settlements both sides agree to. They don't dig into the fine print the way they would in a contested trial, because the entire premise of a settlement is that both sides read it and agreed. That's the exact mechanism we're relying on, and it's also going to feel, in the room, like the worst moment of this whole fight. And after? After, we go home. We wait. Simmons's office will need to actually execute the property transfer, file the new deed with the Register of Deeds, notify the mortgage company since there's still a loan on the property that'll need lender consent to any transfer, coordinate with the trust's bank on how the property gets held. That process takes weeks, sometimes longer. Somewhere in that process, somebody on Diane's side, a title company doing due diligence, a bank compliance officer, an actual competent paralegal, is eventually going to pull the full chain of title and see Book 4471, page 209, sitting there. And when they do, they're going to have to explain to Diane why the trust can't actually take the property, despite a signed court settlement saying it can. What if nobody catches it? What if they just file the deed and move on and nobody ever checks? Monica considered this seriously because it was, she admitted, a real possibility. "Then we make sure somebody checks," she said. "I have a friend at a title company downtown. If it comes to that, I'll make sure the memorandum gets flagged during any future title search on that property, which happens automatically, by the way, the moment anyone tries to get title insurance, sell the property, or refinance it, all of which Diane will eventually want to do with a property she believes she now owns free and clear. There's no version of this where that document stays buried forever, Claire. The only real question is how long it takes to surface, and how much cleanup we have to do in the meantime." I asked her, that night, the question I had been almost afraid to ask for weeks. "Do you think this is going to work?" Monica was quiet for a moment, looking out at the dark street, at the gas lamp glow that Charleston's downtown has kept, stubbornly, for 2 centuries. "I think," she said finally, "that Diane Whitfield has spent her entire life operating on the assumption that the people around her are either too intimidated, too tired, or too trusting to check her work. I think that assumption has been correct often enough that she's stopped even considering the alternative. Tomorrow, we're betting everything on the idea that just once, somebody is finally going to check." Charleston County's probate court occupied a wing of the old courthouse on Meeting Street, all marble floors and high plaster ceilings, the kind of building that makes everyone who walks into it, guilty or innocent, plaintiff or defendant, feel small and slightly out of breath. I wore a navy dress my mother had helped me choose. "Nothing too somber, nothing too composed," Monica had advised. "Just something that looked like a woman trying to hold herself together and mostly succeeding," which was, if I'm honest, not really a costume at all. Diane arrived 12 minutes early, in the cream Chanel suit I described at the very beginning of this story, with Vanessa beside her and Gerald Simmons a step behind, carrying a leather folio like a man carrying a trophy he already knew he'd won. She smiled at me across the hallway outside the courtroom, not unkindly, exactly, which somehow made it worse. It was the smile of someone who believed, genuinely, that she had done nothing wrong, that she was simply, finally, restoring order to a family that had drifted from its proper structure. Judge Patricia Hall was a small, precise woman in her 60s who had, according to Monica, presided over Charleston County probate matters for almost 2 decades and had a reputation for moving through settled matters efficiently, reserving her real scrutiny for genuinely contested hearings. She called the case, in Re the Whitfield Family Trust, at 9:40 that morning, and the proceeding that followed lasted, in total, perhaps 25 minutes, though it felt, sitting inside it, like several separate lifetimes compressed into a single overheated room. Gerald Simmons spoke first, summarizing the settlement for the court in the smooth, unhurried cadence of a man delivering a speech he'd given 100 times before, in 100 other rooms, to 100 other exhausted opposing parties. He described the agreement as a fair and comprehensive resolution reached after extensive good-faith negotiation, noted that the property at 14 Trad Street would transfer to the Whitfield Family Trust in full and final resolution of all turnover claims with counsel, understood its terms, and was entering into it voluntarily. I said yes, when asked directly by the judge whether I understood I was agreeing to transfer the property, and I felt the specific vertigo Monica had warned me about, the sensation of a truth being entirely real in my body, the loss, the surrender, the humiliation of it, existing at the exact same moment as a quieter, harder truth underneath it that I alone, in that room, besides Monica sitting 2 rows back in the gallery, actually understood. Judge Hall reviewed the settlement documents for what felt like an eternity and was probably closer to 90 seconds, asked one procedural question about the Education Trust's funding schedule, received Simmons's answer, and then looked up and said the words that still visit me sometimes, unbidden, at 3 in the morning. "This court finds the settlement fair, voluntary, and in the best interests of all parties, including the minor children. The agreement is approved. Ms. Whitfield, if you'll sign where indicated." I signed. Preston signed as counsel. Gerald Simmons signed on behalf of the trust, with Diane's countersignature as trustee beneath his. The clerk stamped the final page with the particular thud that court stamps make, a sound with a strange finality to it no matter what side of a case you're on, and it was, on paper, entirely, unambiguously done. I had signed away my home. That was the exact moment Diane made the sound. She was sitting 2 rows behind me, close enough that I heard it clearly. That small, satisfied exhale through her nose, the specific sound of a woman who believes she has finally, after 4 years, put me back in whatever box she'd always believed I belonged in. She leaned toward Gerald Simmons and said, just loud enough for me to catch, "Well, that's that then." And I watched, out of the corner of my eye, as she smiled the smile I'd first seen on a porch on Sullivan's Island 12 years earlier, back when I was 26 years old and had no idea yet what that smile actually cost the people it was pointed at. I did not cry in that courtroom, though everyone watching me, I suspect, assumed I was holding back tears of grief and defeat. I was holding back something else entirely, the almost unbearable urge, sitting 6 feet from Monica Reyes, to look at her, to let some flicker of the truth cross my face. I did not let myself. I kept my eyes on the table in front of me, on my own hands, still faintly trembling, and I let Diane Whitfield have her 25 minutes exactly as she wanted them. Outside the courthouse, on the marble steps, Diane actually hugged me, an unprompted, oddly genuine gesture that confused me more than almost anything else that day, and said, close to my ear, "I know this feels hard now, Claire, but someday you'll understand I did this for the children, for the family." I did not trust myself to answer. I simply nodded and let her believe, for a little while longer, that she had won. The weeks that followed the hearing were, in their own way, harder than almost anything that had come before them, because for the first time in over a year, there was nothing active to fight, no motion to respond to, no hearing to prepare for, only waiting, and the particular psychological toll of waiting for something you cannot control and cannot rush. Diane, in the immediate aftermath of the settlement, behaved exactly as Monica had predicted she would. Expansively, almost giddily gracious, the graciousness of the victor rather than the vanquished. She called to invite the children for a weekend at Sullivan's Island, now that things are settled. She sent Sophie a gift, a set of watercolor paints, with a card that said, in her elegant slanted handwriting, "For my talented granddaughter. I hope our family can heal now that the hard part is behind us." She mentioned, in a call I recorded, legally, with Monica's careful guidance on South Carolina's one-party consent laws, a detail that would matter enormously later, that she was so relieved this whole ordeal is finally over, and that she'd already spoken to a property manager about eventually renting the Trad Street house out, once everyone settled elsewhere, as an investment for the children's education fund. That call terrified me more than almost anything in the entire ordeal, because it meant Diane was already planning to act on an ownership she did not, in fact, hold. Monica, when I told her, was more reassuring than I expected. "That's actually useful," she said. "The more concretely she moves to exercise control over that property based on the settlement, the more clearly documented her reliance on a transfer that never legally took effect. If this ever needs to go back in front of Judge Hall, that phone call helps us, not her." 6 weeks after the settlement, the mechanism Monica had predicted finally began to move. Gerald Simmons's office, working to formalize the trust's new ownership, engaged a title company to update the property's insurance policy and prepare the new deed for recording. A routine administrative step that virtually never draws scrutiny, except that this particular title company, as it happened, employed a senior examiner named Ruth Alcott, who had 22 years earlier trained under Harold Voss himself before he retired from active practice, and who still, out of old habit and old respect, read every recorded instrument on a chain of title in full, rather than relying solely on the automated title search summary most examiners trusted without question. Ruth Alcott found Book 4471, page 209, on a Thursday afternoon in early December. She read it twice. And then, According to what Monica pieced together afterward through channels I still don't fully understand, she picked up the phone and called Harold Voss directly, retired or not, because some habits, checking your work, respecting the intentions of the dead, apparently outlast a career. I had not spoken to Harold Voss since Daniel's funeral, where he'd stood at the back of the church, a small, stooped man in his 70s, with a gray mustache and the particular stillness of someone who has spent a career keeping other people's secrets. He called me directly on a Friday evening in December, a little after 7, while I was helping Noah build a Lego dinosaur at the kitchen table, and I almost didn't answer, because I didn't recognize the number, and because by then almost every unfamiliar call made my stomach clench with something close to dread. "Claire," he said when I picked up. "It's Harold Voss. I hope you'll forgive the intrusion. I think we should talk. Somewhere private, if you're able." We met the following Monday at his old office downtown, which he still kept a small part-time presence in even 3 years into what he called his reluctant retirement. Monica came with me, and Harold, when he saw her, gave a small, knowing nod, as though he'd already half-guessed at her role in things before we said a word. "Ruth Alcott called me Thursday," he said, once we were all seated, his hands folded on his desk in a gesture that reminded me, unexpectedly and painfully, of Robert. "She found the memorandum during a title examination for the Trad Street property. She wanted to know if I could confirm its authenticity and its circumstances, since it's unusual to see language that specific and that carefully anticipatory in a document that old." He looked at me directly. "I can confirm both. I drafted that document myself, at Robert's explicit and detailed instruction, 11 years ago, specifically because he was afraid of exactly what has now happened." "He knew," I said again, the way I kept saying it, as though repeating it enough times might make the grief of it settle into something bearable. "He knew his wife," Harold said simply. "He loved her, Claire. I want to be clear about that, because I don't think it's fair to flatten a 35-year marriage into a villain's origin story. But he also understood her completely, in the specific way that only decades of marriage allow, and he told me once. I remember the conversation almost word for word, because it struck me as unusually candid for him, that Diane had a talent for convincing herself that whatever she wanted was also, coincidentally, what was morally correct, and that once she'd convinced herself of that, no argument on earth could move her. He wasn't trying to punish her by protecting you. He was trying to build a wall strong enough that she'd never even be tempted to test it, because he knew, better than anyone, that she would test it eventually, if given the smallest opening. "Why didn't you tell Diane the memorandum existed? Or tell her lawyer, once the petition was filed?" Harold's expression tightened slightly. "Because Robert instructed me, specifically in writing, not to disclose its existence to Diane during his lifetime or after his death, unless it became necessary to protect Daniel's, or your, interest in the property. I take instructions like that seriously, Claire. It's not my job to referee family disputes preemptively. It's my job to make sure my client's wishes are carried out when the moment actually arrives." The moment arrived. I would have come forward myself eventually, if you and Ms. Reyes hadn't already found it. I was watching the probate docket, quietly, from a distance, more closely than perhaps I should admit. I'm relieved I didn't have to intervene, honestly. It reads better this way. It reads like Diane's own case defeated itself, rather than like an old man reaching from retirement to save the day. Monica leaned forward. "Mr. Voss, I need to ask you something more delicate, and I understand if you're not able to answer fully. In the original petition, Diane represented herself to the court as the sole surviving trustee of the Whitfield Family Trust, with full authority to bring a turnover action. Is that representation accurate?" Harold was quiet for a long moment, the particular quiet of a lawyer deciding exactly how much he's willing to say, and about what. The trust as Robert originally structured it, he said finally, named Diane and a corporate trustee, a bank trust department, as co-trustees, specifically so that no single individual, including Diane, could unilaterally direct significant trust actions without an independent check. Approximately 8 months after Robert's death, Diane petitioned to remove the corporate co-trustee, representing to that court that the corporate trustee had resigned voluntarily due to the trust's modest asset size. I have reason to believe that representation was not entirely accurate. What Harold told us that afternoon, carefully, in the measured language of a man who clearly understood the weight of what he was saying, was this. The corporate trustee, a regional bank trust department, had not resigned voluntarily at all. They had, according to internal correspondence Harold had seen years earlier in his role as trust counsel, expressed serious reservations about several trust distributions Diane had proposed in the 2 years following Robert's death, including, notably, an attempt to redirect a portion of trust assets toward a real estate investment company, owned in part by Vanessa's husband, a transaction the bank's trust officers had flagged as a potential conflict of interest and declined to approve. Rather than fight the bank's objections through the trust's ordinary dispute mechanisms, Diane had petitioned the probate court directly, representing that the corporate trustee wished to resign due to the trust's size, a claim that, if the bank's own file told a different story, was not simply an aggressive legal maneuver. It was, potentially, a material misrepresentation made to a court, under a filing Diane herself had signed and sworn to be true. I want to be careful here, Harold said. I'm telling you what I observed as trust counsel at the time, which creates its own complicated questions about my own obligations, questions I've thought about a great deal since Ruth's call. I did raise concerns with Diane privately when the removal petition was filed. She told me, and I quote as precisely as memory allows, "The bank was being needlessly difficult, Harold, and I have every right to manage my own husband's trust without a stranger looking over my shoulder." I did not believe, at the time, that I had sufficient grounds to intervene formally. A trustee removal proceeding between a trustee and a corporate co-trustee isn't unusual on its face, and I wasn't privy to every detail of the bank's internal reasoning. But given what's happened since, given that she then used her resulting sole authority to bring a turnover petition against property the trust never had any legitimate claim to, I think it's fair to say a pattern has become visible that wasn't fully visible to me at the time. Monica had gone very still, the particular stillness of a lawyer recognizing that a case has just become considerably larger than she'd originally understood it to be. Mr. Voss, she said slowly, if Diane misrepresented the circumstances of the corporate trustee's departure in a sworn court filing, and then used the resulting sole trusteeship to bring a second sworn petition asserting rights over property she knew, or should have known, the trust had explicitly waived, that's not just an aggressive legal strategy anymore. Depending on what actually happened with that bank, that starts to look like a fairly serious pattern of misrepresentation to a probate court, across 2 separate proceedings, 4 years apart. I believe, Harold said carefully, that it would be worth someone reaching out to that bank's trust department directly to ask what actually happened. I'm not in a position to make that call myself, but I don't believe I'd be violating any obligation by confirming, if asked directly by appropriate counsel, that the resignation letter I reviewed at the time struck me, even then, as somewhat unusual in its phrasing. I left that meeting with Monica in a kind of stunned quiet that lasted most of the drive home, the particular stillness of understanding that something you believed was a private, contained family wound might, in fact, be the visible edge of something considerably larger and darker than you'd ever let yourself imagine. What does this mean? I finally asked. For the settlement? For the house? The house is fine, Monica said. The house was always fine, from the day we drafted that settlement language. This is bigger than the house now, Claire. If what Harold's describing is accurate, Diane has misrepresented material facts to a South Carolina probate court not once, but potentially twice, in service of consolidating control over trust assets she wasn't entitled to control. That's not a family disagreement anymore. That's the kind of thing that can end with a trustee removed for cause, and depending on how a judge views the sworn misrepresentations, potentially referred for further review. I should say, honestly, that some part of me flinched at that. Whatever Diane had done to me, whatever cruelty she'd inflicted across a decade of small cuts and one enormous one, she was still Sophie and Noah's grandmother. Still the woman who had once, genuinely, wept with me on my own front hallway floor. I did not relish the idea of her facing serious legal consequences, but I also understood, with a clarity that surprised me, that protecting my children eventually meant something larger than protecting my own discomfort about their grandmother's reckoning. If Diane was willing to lie under oath to seize control of her grandchildren's home, I needed to know the full shape of what else she might be willing to do, and I needed a court, not just a family dinner table, to be the place that finally drew a line she couldn't argue her way around. I did not witness the moment Diane learned that her victory had a hole in it. I only learned about it secondhand, weeks later, from Vanessa, of all people, in a conversation that itself marked the beginning of a strange and unexpected shift in how at least one member of that family finally saw me. According to Vanessa, Gerald Simmons called Diane on a Wednesday morning in mid-December, his usual smooth confidence audibly absent, to inform her that the title company handling the property transfer had flagged an issue with a recorded instrument that appeared to predate and potentially supersede the trust's newly acquired interest in the Trad Street property. He used, Vanessa said, an enormous amount of careful hedging language. Appears to, may present complications. We're evaluating our options. The specific verbal camouflage of a lawyer who has just realized he built a beautiful house on a foundation someone forgot to check. Diane's response, again according to Vanessa, was not immediate panic. It was, initially, imperious dismissal. "I'm sure it's nothing that can't be resolved," she reportedly said. Claire signed a settlement in open court. A judge approved it. I don't see how some old piece of paper changes anything a judge has already decided. It took Gerald Simmons and eventually a second attorney he brought in from his firm's real estate group the better part of 2 weeks to fully explain to Diane why, in fact, a properly recorded memorandum executed by the trust's own grantor, restricting the trust's authority over specific property, absolutely could and did undermine a settlement agreement that had never actually granted the trust an interest it was capable of holding to begin with. I understand, from Vanessa, that this explanation did not go well. I understand there was shouting. I understand Gerald Simmons's firm eventually assigned a different, more senior partner to handle the sensitivity of the matter going forward. Legal code, apparently, for we would like our angriest client speaking to someone other than the associate she's currently screaming at. Diane called me directly on a Sunday evening in early January, and I want to describe that call carefully, because it was, in many ways, the last real conversation of its kind I would ever have with her. The last time she spoke to me as though she still believed she held every card. "I don't know what you and that lawyer of yours think you're doing," she said, without preamble, the moment I answered. "But I signed a settlement in good faith, Claire. A judge approved it. If you think some technicality is going to let you weasel out of an agreement you made under oath." "Diane," I said, and I made myself keep my voice steady, the way Monica had coached me to, weeks earlier, in anticipation of exactly this call. "I didn't weasel out of anything. I signed exactly what the settlement said. The settlement incorporated a document that's been recorded at the Register of Deeds office for 11 years. Nobody hid anything from anyone who bothered to read it. Robert would never have." "Robert did," I said. Robert had Harold Voss draft it specifically because he knew you might try something like this someday. I'm sorry that's hard to hear. But it's true. And I think, if you're honest with yourself, some part of you already knows it's true. There was a long silence on the line, long enough that I genuinely wondered if she'd hung up. When she finally spoke again, her voice had changed. Not softer exactly, but different, stripped of some of its usual polish. You think you've won something? She said. You think this makes you clever. It doesn't. It just makes you the kind of person who lets an old man's paranoia turn a family apart at the seams. I think, I said, that I've spent 11 years trying to be part of this family, and that you spent every one of those years making sure I understood I never fully would be. I didn't ask for any of this, Diane. I didn't go looking for a fight. You filed a lawsuit against your own grandchildren's home 4 months after your son died. I'm not the one who tore this family apart at the seams. I just happened to be the one who finally stopped letting it happen to me without a fight. She hung up without responding. It would be another 5 months before she spoke to me directly again, and by then, the shape of everything between us had changed in ways neither of us could have fully anticipated on that January phone call. Monica, working with a colleague who specialized in fiduciary litigation, filed a motion in late January asking the probate court to compel production of the corporate trustee's full internal file regarding its resignation from the Whitfield Family Trust 4 years earlier. The file Harold Voss had gently, carefully suggested existed, without ever quite saying so directly. The bank, once formally subpoenaed rather than merely asked informally, produced records that confirmed almost exactly what Harold had implied. Internal emails between the bank's trust officers, spanning several months, documented growing concern over Diane's proposed distributions, not only the real estate investment involving Vanessa's husband, but 2 additional transactions the bank's compliance department had flagged as potential self-dealing, including a proposed family advisory fee. Diane had suggested paying herself, as trustee, for time spent overseeing trust administration, a fee structure the trust document did not actually authorize. The bank's resignation letter, which Diane had characterized to the probate court as voluntary and related to the trust's modest asset size, turned out, on its face, to say something considerably more direct: that the bank was resigning as co-trustee due to irreconcilable disagreements regarding proposed distributions that the trust department believes may not align with the grantor's original intent, and out of an abundance of caution regarding potential conflicts of interest. Diane's court filing had simply omitted that second sentence entirely, presenting only the bank's formal, boilerplate resignation notice while quietly leaving out the actual substance of why the resignation had occurred. Monica showed me the documents at her kitchen table, the same table where she'd first found the memorandum months earlier, and I remember feeling something I hadn't expected to feel at that particular moment. Not triumph, exactly, but a kind of exhausted clarity, the specific relief of finally seeing an entire shape you'd only ever glimpsed in fragments before. This isn't just about the house anymore, Monica said quietly. This is a pattern of a trustee misusing her position for years and misrepresenting facts to a court to consolidate power when anyone tried to check her. I think we file a formal petition to remove her as trustee for cause, and I think, given what's in this file, we have a real shot at getting it granted. What happens to her if that happens? Removal as trustee, most likely, and probably a requirement that she provide a full accounting of every distribution she's made or attempted to make since Robert died, which the corporate trustee's replacement, likely another bank, or possibly even Harold himself in a limited advisory capacity, would then review carefully. If that accounting turns up further irregularities, and depending on how the judge views the sworn misrepresentations across both petitions, there's a real possibility this gets referred to the State Attorney General's office for further review, or at minimum results in a judicial finding that could follow her for the rest of her life in any future fiduciary role she might seek. I sat with that for a long time before I said anything else. I don't want to destroy her, I said finally. I want this to stop. I want my children to grow up without watching their grandmother go to prison over a house. Is there a version of this that just stops it without going that far? Monica considered this seriously, because she always did, because for all her sharpness, she never once treated my discomfort as an obstacle to be managed rather than a genuine consideration worth honoring. There's a version, she said slowly, where we use the threat of the removal petition and everything in that bank file as leverage to negotiate a resolution that removes her authority permanently without necessarily pursuing the most punitive outcomes available. It would mean she loses trusteeship entirely, submits to a full accounting under independent supervision, and formally, permanently, waives any future claim against the Trad Street property or against you directly. In exchange, we don't push for a referral to the Attorney General, and we don't make any of this public beyond what's already part of the court record. It's not full accountability. But it might be enough to actually stop her permanently, while leaving room for whatever relationship your children eventually choose to have with her. Do that, I said. Whatever version gets us there fastest, without a criminal referral hanging over the kids' heads for the rest of their childhoods. That's the version I want. The removal petition never actually required a full contested hearing in the end, though it came close enough that Monica had prepared me for the possibility of testifying, of sitting in that same marble-floored courtroom and answering questions under oath about a decade of small cruelties that had never before had a formal name. 3 weeks after Monica filed the petition, accompanied by the bank's internal file and a sworn declaration from Harold Voss regarding the circumstances of the memorandum's drafting, Gerald Simmons's firm, the senior partner now fully in charge of the sensitivity of the matter, a calm, gray-haired man named Whitaker who treated me with a courtesy his junior colleague had never bothered with, reached out to Monica directly to negotiate a resolution rather than proceed to a hearing neither side, by then, particularly wanted. The final consent order, which Judge Hall signed in chambers without either Diane or me needing to appear in person, a mercy I remain grateful for even now, provided for Diane's immediate and permanent resignation as trustee of the Whitfield Family Trust, to be replaced by a new corporate trustee selected jointly by the parties. It required a full accounting of all trust distributions and proposed distributions since Robert's death to be reviewed independently. It formally, permanently, and irrevocably waived any claim, present or future, by Diane, the trust, or any successor trustee, to the Trad Street property or to any asset titled solely in my name or jointly in my and my children's names. And it included a confidentiality provision that kept the specific findings of the bank's internal file and the full extent of what might have constituted actionable misrepresentation out of any public docket beyond the bare fact of trustee removal. The mercy Monica had negotiated on my behalf, the mercy I had asked for. I signed nothing that day. There was nothing left for me to sign. That, more than almost anything else, is the detail that has stayed with me longest, that the entire resolution of a battle that had consumed 1.5 years of my life, that had cost me sleep and money and a version of trust in the world I don't think I'll ever fully recover, concluded with a document I never even had to put my name on, because for the first time in that entire fight, I wasn't the one being asked to give something up. Diane, I later learned, did sign it in Whitaker's office, with considerably less ceremony than the settlement she'd once celebrated in open court. Vanessa told me, months later, that Diane had cried afterward, not performatively, not for an audience, but alone, in her car in the parking garage outside Whitaker's office, for almost 40 minutes before she felt able to drive home. I did not feel triumphant when Vanessa told me that. I felt mostly a tired kind of sorrow for a woman who had spent her entire adult life building an identity around control and certainty, and who had just watched both of those things dissolve in a single afternoon, undone by a piece of paper her own dead husband had quietly left behind, specifically because he'd understood her better than she'd ever understood herself. I did not expect Vanessa Cole to become, in any sense, an ally in the aftermath of everything that happened, and I want to be honest that our relationship remains, even now, complicated and imperfect, rather than some tidy redemption arc. But something in her did shift, gradually, over the months following the trustee removal, and I think it's worth telling honestly, because it says something true about how these family reckonings actually unfold in real life. Messily, incompletely, with people changing by degrees rather than all at once. Vanessa called me in March, almost 3 months after the consent order was signed, and asked if she could come by. I said yes, mostly out of curiosity, and she arrived at the Trad Street house. My house. Still my house. A fact I still occasionally had to remind myself of with a small jolt of relief, carrying a bottle of wine and an expression I hadn't seen on her before. Something like shame, worn uneasily, the way a person wears a coat that doesn't quite fit. "I owe you an apology," she said, sitting across from me at the same kitchen table where, years earlier, she'd delivered Diane's first careful hints about trust funds and questions over a salad neither of us had eaten. For the casseroles, for the questions I asked Sophie. I told myself I was just checking on the children. I wasn't. I was gathering information for Diane, and I knew it. And I did it anyway, because I've spent my whole life being a little bit afraid of disappointing her, and it was easier to do what she wanted than to ask myself whether what she wanted was actually right. I didn't say anything for a moment, turning the wine glass in my hand. "Why now?" I finally asked. "Why the apology now, and not 6 months ago?" "Because," Vanessa said, "watching what happened to her, the accounting, the trustee removal, all of it, I finally had to ask myself a question I'd been avoiding for years. Did I actually believe you were dangerous to this family? Or did I just believe Diane, because believing Diane has always been easier than doubting her?" She looked down at her hands. "I don't think you were ever the problem, Claire. I think I convinced myself you were, because it was more comfortable than admitting my sister-in-law was capable of what she turned out to be capable of. I'm sorry it took this long for me to say that out loud." I told her, honestly, that I appreciated the apology, and that I didn't know yet what I wanted our relationship to look like going forward, and that I needed her to understand that Sophie and Noah's well-being would always come before any effort at smoothing things over for the sake of appearances. She said she understood. Over the following year, slowly, carefully, she became something like a real aunt to my children, not a replacement for anything, not an erasure of what had happened, but a genuine, if late, correction, the kind that matters more, I've come to believe, precisely because it was earned rather than assumed. I want to resist the temptation, in telling this story, to flatten Diane Whitfield into a simple villain who got what she deserved, because the truth of what happened to her afterward is more complicated than that, and because I think the complicated version is actually more honest and more useful than the simple one. She lost the trusteeship permanently. She lost, for a time, most of her standing in the small, tightly wound social circle she'd spent decades cultivating on Sullivan's Island, because word travels in small communities regardless of confidentiality provisions, and enough people eventually understood, in broad outline if not in specific legal detail, that Diane Whitfield had tried to take her own grandchildren's house and had lost badly enough to be removed as trustee of her late husband's estate. She lost, most painfully, I think, a version of herself she had built her entire identity around: the matriarch, the person who decided things, the center around which the rest of the family arranged itself. She did not lose everything. The trust itself, under new corporate management, continued to fund Sophie and Noah's education exactly as Robert had originally intended, and Diane retained her own considerable personal assets, separate from the trust, along with the Sullivan's Island house, which had never been part of any dispute. She did not go to prison. She was not publicly humiliated beyond the natural gossip of a small community putting pieces together on its own. The mercy Monica had negotiated on my behalf, the mercy I had specifically asked for, thinking of my children more than of Diane herself, held. I saw her exactly twice in the 18 months following the trustee removal, both times briefly, both times at events I couldn't reasonably exclude her from: Sophie's 9th birthday, and a Christmas gathering I hosted mostly for the children's sake, inviting Diane along with Vanessa and a handful of Daniel's old friends, in an attempt to give my children something that at least resembled a normal, extended family. Even if the adults in the room carried complicated histories, none of us discussed out loud. Diane was quieter at both events than I had ever known her to be. Not broken, exactly, but diminished in a way that made me feel, unexpectedly, a flicker of something almost like compassion, buried underneath everything else I still, honestly, felt toward her. She never apologized to me directly, not once, not even obliquely. I don't know if she ever will. I've made a kind of peace with that, over time, not because it doesn't still sting, on the occasional bad day, but because I've come to understand that some people are constitutionally incapable of the specific vulnerability an apology requires, and that waiting for that particular gift from a person who has never once demonstrated the capacity to give it is its own kind of self-punishment. I stopped waiting. It was, I think, one of the healthier decisions I made in that entire long ordeal. I still live in the house on Trad Street. I am writing parts of this from the same kitchen table where Monica first found the memorandum, in the same room where Daniel once told me, almost as an afterthought, about an insurance policy his father had insisted on, years before either of us understood what it would eventually insure against. The plumbing finally got fully replaced 2 years ago, a project I paid for myself, slowly, one bathroom at a time, out of my own nursing salary and a small promotion to charge nurse that came with exactly the kind of raise that makes old pipes finally feel affordable. The heart pine floors still groan in all the same places. Sophie is 13 now, taller than me, still fiercely direct in the way she's been since she was small, currently obsessed with marine biology rather than horseshoe crabs specifically, though I suspect the horseshoe crab started it. Noah is 10, gentle like his father was, an enthusiastic and objectively terrible little league pitcher whose enthusiasm I have never once had the heart to correct. I think about Robert Whitfield often, more often, if I'm honest, than I think about most of the people who are still alive in my life, which feels strange to admit, but also feels true. I think about a man standing in an estate attorney's office, years before he died, quietly insisting on language specific enough to defeat a threat he could see coming from a wife he loved and understood in equal, complicated measure. I think about the particular kind of love that looks less like affection and more like foresight. The love that doesn't announce itself, that doesn't need gratitude, that simply, patiently, builds a wall in a place it suspects, correctly, will one day need one. I never got to thank him properly. I try, instead, to thank him by staying, by keeping this house, by raising his grandchildren in the rooms he never got to see finished, by teaching Sophie to fish off the dock at the Sullivan's Island house on the rare occasions we still visit, the same dock where he once rebaited her hook 40 times in an afternoon without a flicker of impatience. Some debts, I've come to believe, aren't repaid to the person who's owed them. They're repaid forward, to whoever comes next. I ran into Preston Hale a little over a year after everything concluded, at a coffee shop near the courthouse, the kind of small, unavoidable Charleston coincidence that happens when you've lived your whole life in a city this size. He looked older than I remembered, or maybe I simply hadn't noticed how tired he'd looked the entire time he'd represented me, too consumed by my own exhaustion to register his. "Claire," he said, half standing from his table, an expression crossing his face that mixed genuine warmth with something more uncertain. I heard a version of how things ended up. I'm glad. Genuinely. I sat down across from him, mostly because I realized, somewhat to my own surprise, that I wanted to. "I want to ask you something," I said, "and I want an honest answer, not a diplomatic one." "Okay. Did Gerald Simmons approach you, during the litigation, about steering me toward a settlement? Before we brought you the memorandum?" Preston was quiet for a long moment, turning his coffee cup slowly on its saucer. "Not in so many words," he said finally. "He mentioned, more than once, in the casual way opposing counsel does, that his client had significant resources and no interest in a protracted fight, framed as though he were doing me a favor by flagging it early. I don't think he ever explicitly asked me to advise you toward settlement. I think he understood correctly that simply reminding me how expensive and exhausting the alternative would be was enough to do the work for him, without him ever having to say anything an ethics board could object to." He looked up at me. "I should have pushed harder when you brought me that memorandum. I told myself I was being appropriately cautious about litigation risk. Looking back, I think I was just tired, and a fast settlement felt easier than a hard fight, and I let that feeling do more of my thinking than it should have. I'm sorry, Claire. I mean that." I told him I appreciated the honesty, and I meant it. And I also told him, honestly, that I'd learned something important from the experience that had nothing to do with him specifically. That competence and advocacy aren't always the same quality in a person. That a lawyer can be perfectly skilled at the mechanics of law, and still, under the specific pressure of exhaustion and constrained resources, guide a client toward the path that costs the lawyer the least energy rather than the path that best serves the client. It wasn't malice. It was something more human and more common than malice, and understanding that difference has made me, I think, a more careful judge of who I trust with the things that matter most in my life. Monica Reyes opened her own practice 18 months after the settlement concluded, a small trusts and estates firm downtown that now, unsurprisingly, specializes in exactly the kind of case she built for me, protecting surviving spouses and children from exactly the kind of quiet, patient family maneuvering that almost cost me my home. She still teaches the same spin class instructor's Saturday session, which is how, 4 years after we met over a confused conversation about staring at walls during warm-up, we ended up godmothers to each other's second children, an arrangement neither of us saw coming and both of us now treasure completely. I asked her once, at dinner, why she'd taken such an enormous professional risk on my case, why a young attorney building her own client base had spent months of unpaid informal work crafting a strategy this intricate for a nurse she'd met at a gym, with no guarantee of ever being formally retained or compensated for any of it. She thought about the question seriously before answering, which was, by then, entirely characteristic of her. "Because," she said, "I grew up watching my own mother get squeezed out of a family business after my grandfather died, by an uncle who understood the paperwork better than she did and made sure it stayed that way. I watched a woman who deserved better lose something because nobody in her corner knew how to actually read the documents that mattered. I became a lawyer specifically so that the next time I saw that happening to someone, I'd know exactly what to do about it. You weren't a charity case to me, Claire. You were the exact situation I went to law school to be useful for. I think about that conversation often, particularly on the days when the whole ordeal still surfaces unexpectedly. A familiar smell that reminds me of the probate courthouse, a certain tone of voice that echoes something Diane once said, the particular vertigo that returns, occasionally, out of nowhere, when I remember signing that settlement and hearing her exhale through her nose behind me. Monica's answer reminds me that the worst chapters of a life sometimes produce, alongside all the damage, genuinely unexpected gifts. A friendship I would not otherwise have. A clarity about my own resilience I did not know I possessed. A understanding of exactly what I am capable of protecting when the people I love are threatened. I have not, in this telling, spent much time on the ordinary, unglamorous work of grieving Daniel underneath everything else that was happening. The legal battle, the memorandum, the courtroom performance, the eventual reckoning. That's partly a function of how the story needed to be told, but it's also, if I'm honest, a reflection of how grief actually worked for me during that entire period. It never stopped. Not for a single day, even while an enormous, complicated legal drama unfolded on top of it. I want to say that clearly, because I think it matters, and because I don't want anyone reading this to imagine that the fight with Diane somehow eclipsed or replaced the deeper loss underneath it. I still miss him in small, specific, unglamorous ways that have nothing to do with courtrooms or trusts. I miss the way he hummed off-key while making coffee. I miss watching him explain building elevations to Sophie with more patience than any 6-year-old deserved or required. I miss the particular sound of his key in the door on nights he came home late from a site visit, a sound I still, embarrassingly, sometimes think I hear, years later, in the half-second before I remember. Grief counseling helped, eventually, once I finally allowed myself the time for it. A kind, unhurried therapist named Dr. Adaora Nwosu, who never once tried to rush me toward moving on, and who told me, in one of our early sessions, something I've held on to since, that grief and vigilance can look identical from the outside, both of them keeping you scanning constantly for the next loss. And that part of my healing would involve learning to tell the difference between genuine caution and a nervous system that had simply forgotten how to feel safe. The legal fight with Diane, in some strange way, gave that hypervigilance a legitimate target for a while, a real threat to focus on, rather than the formless terror of losing someone else I loved to circumstances entirely beyond my control. I don't think that's a healthy long-term strategy for processing grief. But I understand now why it happened that way, and I've forgiven myself for needing it. I started dating again about 3 years after Daniel died. Carefully, slowly, mostly at Monica's gentle insistence that I was allowed to want companionship without it constituting any kind of betrayal of what Daniel and I had built. I'm not going to detail that part of my life extensively here, because this story was never really about romance, and because some chapters of a life deserve to stay a little bit private even in a telling this thorough. I'll say only that I found, eventually, a version of peace that includes room for new people, without requiring me to set down or diminish what I carry for Daniel. Both things can be true. I've learned that grief, like the strange truth Monica taught me before that courtroom hearing, doesn't have to be the only truth available to you, even while it remains, entirely and permanently, true. Children process trauma differently than adults do, in ways that surprised me constantly throughout this entire ordeal, and continue to surprise me even now, years later, as I watch Sophie and Noah grow into people who carry this story as part of their history, without it defining the whole of who they are. Sophie, who was 8 when Daniel died and 9 by the time the settlement finally resolved itself, asked me questions throughout that entire period with a directness that occasionally left me speechless. Not cruel questions, just uncomplicated ones, the kind only a child who hasn't yet learned to soften hard truths with diplomatic language can ask. "Is Grandma Diane a bad person?" she asked me once, maybe 6 months after the trustee removal, while we were folding laundry together on a Sunday afternoon. I remember thinking carefully about how to answer that, because I didn't want to poison her against her grandmother permanently, and because I also didn't want to lie to her about something she clearly already sensed was true. "I think," I finally said, "that Grandma Diane did some things that hurt our family very badly, and that she made choices that weren't fair to you, or to me, or to your dad's memory. I don't think that makes her a bad person in every single way there is. I think it means she made some very bad choices, and that grown-ups, just like kids, have to face consequences when they make choices like that." Sophie considered this with the particular seriousness she brings to everything. "Did the consequences work?" she asked. "Did she learn?" I told her the truth. I didn't know. I still don't. Entirely. I know Diane lost her trusteeship, lost some of her standing, lost, I suspect, a version of certainty about herself that she'll probably never fully recover. Whether any of that translated into genuine self-reflection, into something that resembles real change rather than mere consequence, is a question only Diane herself could answer, and she has never once, in all the years since, offered me anything close to an honest answer to it. Noah, younger and gentler, processed things differently, less through direct questions and more through a kind of quiet clinginess that lasted for months after the settlement hearing, a need to know exactly where I was in the house at all times, a habit of checking, every night before bed, that the doors were locked, a habit I eventually understood as his particular way of managing a fear he didn't yet have words for. The fear that the people he loved could simply disappear, or be taken, without warning, the way his father had been. We worked through that fear slowly, together, with Dr. Nwosu's guidance and an enormous amount of patience, and by the time Noah turned 8, the nightly door-checking had faded into an ordinary, unremarkable childhood, one where his biggest daily concern was whether his little league coach would finally let him pitch a full inning without a mound visit. I count that transformation, from a child terrified of disappearance to a child mostly worried about baseball, among the things I am proudest of in my entire life, more proud of it, honestly, than I am of anything I accomplished in that courtroom. I found Robert's letter almost 2 years after his death, tucked into an envelope inside a book of poetry he'd given me for Christmas the year before he died, a detail I only discovered because Sophie, going through our bookshelves one rainy afternoon looking for something to read, pulled the book down and the envelope slipped out onto the floor. It was dated 8 months before he died, addressed simply to Claire in his familiar, slightly cramped handwriting. I sat down on the floor of that living room and read it 3 times before I could make myself stand back up. He wrote about watching Daniel change since we married. Steadier, he said, more himself, less anxious about earning approval he'd spent a childhood chasing. He wrote about watching me with Sophie, then a toddler, and recognizing in me the same instinct toward quiet, unglamorous devotion he'd valued in his own mother, a woman who'd died when he was young and whom he rarely spoke about. And then, near the end, he wrote the paragraph that has stayed with me every single day since. "I've set some things in motion that I hope you'll never need, Claire. I love my wife. I want to be honest that loving someone and trusting them completely with everything you have are not always the same thing, and I've come to understand, across 30-some years of marriage, that Diane's love for this family sometimes gets tangled up with her need to control it, in ways I don't think she fully sees in herself. I'm not writing this because I expect the worst. I'm writing it because I'd rather you have protection you never need than need protection you never have. Take care of my son. Take care of yourself. And if it ever comes to it, and I truly hope it never does, don't be afraid to fight for what's actually yours. You've earned it. Every bit of it. I never told Diane about that letter. I don't know if I ever will. Some things, I've come to believe, are meant to exist as private conversations between the living and the dead, rather than evidence to be deployed, however satisfying that deployment might feel in the moment. I keep it now in the same fireproof box where the closing binder used to live, alongside Daniel's college ring and a photograph of Robert teaching Sophie to fish off the Sullivan's Island dock the summer before he died. I take it out sometimes, on hard days, and read it again, and I let myself feel, briefly, exactly as protected as he intended for me to feel. The last real conversation I had with Diane happened almost 4 years after the settlement hearing, at Sophie's middle school graduation, a milestone Diane had asked. Carefully, tentatively, if she could attend. I said yes, mostly for Sophie's sake, and Diane arrived early, sat quietly in the back of the auditorium, and afterward, in the crowded lobby full of proud families and terrible cell phone photography, she found her way to where I was standing, briefly alone, while Sophie posed for pictures with her friends across the room. She looks so much like him, Diane said, watching Sophie laugh at something one of her friends said, that particular unguarded laugh that had always been so completely Daniel's. I forget sometimes, and then I see it, and it takes my breath away. She does, I agreed. Diane was quiet for a long moment, and then, without quite looking at me, she said, I think about that day in court sometimes, more than I'd like to admit. Her voice wavered, just slightly, in a way I had genuinely never heard from her before. Not once, not even the night Daniel died. I told myself for a long time that I was protecting the children. I've had a lot of years since then to sit with whether that was actually true, or whether I just wanted it to be true because the alternative was harder to live with. I didn't say anything. I let the silence sit, the way Monica had once taught me silence could do more work than words. I don't expect you to forgive me, Diane said finally. I'm not sure I've fully figured out whether I forgive myself, but I wanted you to know that I know. I know what I did, and I know why it didn't work. And some days I even understand why it shouldn't have. It was not, I want to be clear, a full apology. Not the kind that names specifics, that takes complete ownership, that a therapist might call a clean acknowledgement. It was something smaller and more human than that. An old woman watching her granddaughter laugh with her friends, allowing herself, for one unguarded moment, to admit that certainty is not the same thing as being right. I have not decided, even now, exactly how much weight to give that moment. But I have decided to remember it, because it was the truest thing Diane Whitfield ever said to me in 18 years, and because some part of me, the part that still, despite everything, wants my children to have some version of a grandmother in their lives, needed, badly, for that moment to have been real. I told her simply, "Thank you for telling me that," and I meant it. And then Sophie came bouncing over, diploma in hand, and the moment closed the way these moments always do, swallowed back into the ordinary noise of a life continuing to move forward, imperfectly, the way all lives eventually do. I've thought often, in the years since all of this concluded, about what I would say to someone sitting exactly where I once sat, grieving, exhausted, facing a legal threat from someone who is supposed to love them, wondering whether they have the strength or the resources to fight back. I don't have a tidy list of instructions, because every family, every estate, every courtroom is different. And because the specific mechanics of what saved me, a memorandum recorded 8 years earlier by a father-in-law who understood his wife better than she understood herself, will not exist in most people's stories the way it existed in mine. I got lucky, in a very particular sense, and I want to be honest about that luck, rather than pretend this story is a simple formula anyone can replicate. But there are things I believe are true regardless of the specifics, and I'll share them here, for whatever they're worth to someone reading this in the middle of their own version of this fight. Read everything. I cannot stress this enough, even though I understand, more than almost anyone, how genuinely difficult this is in practice, how exhausting it is to read 50 pages of legal boilerplate while grieving, while working, while parenting alone, while every ounce of your emotional capacity is already spoken for. Read it anyway, or find someone you trust completely to read it for you, and ask that person to explain, in plain language, exactly what every unfamiliar term means. Diane's entire strategy, both in the original petition and in her eventual undoing, depended on people not reading things carefully. My original petition, hers, ultimately, her own settlement agreement. The person who reads most carefully in a family dispute usually holds more power than the person who simply talks the loudest or arrives with the most confidence. Find your Monica. I don't mean you need a friend who happens to be a trust's attorney, though I recognize how specifically fortunate that particular detail was in my case. I mean, find someone in your corner who has both the expertise and the willingness to actually fight for you, rather than someone who will default to the path of least resistance, because a genuine fight is more work than a quiet settlement. Ask direct questions of any professional representing you. Ask what they would do if the stakes were their own. Notice, carefully, whether their advice consistently trends toward whatever requires the least effort from them, because that pattern, once you learn to recognize it, is one of the most reliable signals available to you about whether someone is actually advocating for your interests or simply managing their own workload. Trust document restrictions, memoranda, and similarly obscure-sounding legal instruments are not merely theoretical. If you are entering a marriage where significant family wealth exists on one side, and especially if you sense, even faintly, that a family member might one day contest your claim to something you've built together, it is not paranoid to ask an attorney, your own attorney, independent of your spouse's family, what protections exist and what protections might be worth adding. Robert Whitfield's foresight looked for years like unnecessary caution. It turned out to be the single most important legal document in my entire life. You do not need to expect the worst from the people you love in order to protect yourself sensibly against the possibility of it. And finally, grief does not disqualify you from fighting for yourself. I want to say this directly, because I think it's the lesson that took me longest to actually internalize, even though I understood it intellectually from the very beginning. There is a particular kind of expectation, especially placed on grieving women, that we should be gracious, accommodating, endlessly patient with people who take advantage of our exhaustion, because to fight back while grieving somehow reads as insufficiently sad, insufficiently devoted to the memory of what we've lost. That expectation is wrong, and it is often weaponized, deliberately or not, by people who understand exactly how effectively grief can be used to extract concessions a person would never make with a clear head and full strength. You are allowed to grieve and fight at the same time. I did both, simultaneously, for the better part of 2 years, and I promise you it is possible, even though it is exhausting in ways that are hard to describe to anyone who hasn't lived it. Monica Reyes's firm has grown to 4 attorneys, 3 paralegals, and, as of last spring, a small conference room named, half as a joke, half not, the Memorandum Room, in honor of the case that, according to Monica, taught her more about the actual practice of law than 3 years of her original fellowship combined. We have dinner most Sundays, our children tangled together in the particular chaos of two busy households, merging for a few hours of noise and pasta. Harold Voss retired fully 2 years ago, at 79, and sends Sophie a book every Christmas, always something classic, always with a handwritten note about why he chose it. Last year it was East of Eden, the same book Daniel had been reading the day we met. A coincidence Harold swears was unintentional and that I have chosen, happily, to believe anyway. Preston Hale and I are not close, but we are civil, and he referred a friend of mine to Monica's firm 2 years ago rather than take the case himself, a small gesture that told me he'd genuinely absorbed something from what happened between us. I think that's worth something. I don't think everyone who fails you deserves to remain failed forever, provided they eventually show you, in some concrete way, that they've actually learned. Vanessa remains, imperfectly but genuinely, part of my children's lives. An aunt who shows up for birthdays, who took Sophie to her first concert 2 summers ago, who has never once, in all the years since her apology, tried to relitigate what happened or minimize her own role in it. That, more than any grand gesture, is what earned back whatever trust she has. Gerald Simmons, I understand secondhand, no longer represents Diane in any capacity, a professional relationship that apparently did not survive the fallout of a settlement that failed to deliver what his client believed she was paying for. I have no particular feelings about him one way or another. He was a tool Diane used, skillfully, in service of an argument that turned out to be unwinnable regardless of how skillfully it was pressed. Diane lives alone now on Sullivan's Island, in the same wraparound porch house where I once stood nervously in a blue dress 12 years ago, waiting to see if she would come around. She sees Sophie and Noah several times a year, always at my discretion, always with the boundaries I've set carefully in place, boundaries she has, to her credit, respected consistently since the graduation conversation. I don't know if she's happy. I don't know if happiness is a category she's ever fully allowed herself to occupy, wrapped up as her entire identity has always been in control and certainty rather than contentment. I hope, in whatever complicated way you can hope something for a person who once tried to take your home in a courtroom, that she finds some version of peace before the end of her life. I have made mine with the fact that whether she finds it or not is no longer my responsibility to manage. There is a particular kind of grief that has nothing to do with the past and everything to do with the future. Not missing what someone was, but missing what they'll never get to witness. I feel that version of grief most acutely at the specific unremarkable milestones Daniel never got to see. The ones that don't make it into any eulogy because they're too small, too ordinary, and yet somehow carry more weight than almost anything else. He never saw Sophie lose her first tooth, 3 months after he died, or heard the elaborate mythology she constructed around the tooth fairy's supposed preference for shiny things, which led to a memorable week of Sophie leaving increasingly bizarre offerings under her pillow alongside the tooth itself. He never saw Noah learn to ride a bike, a milestone I documented with the kind of manic, overcompensating enthusiasm of a parent trying to fill an absence with sheer volume of celebration. 6 different photo angles of a 5-year-old wobbling triumphantly down Trad Street while I ran alongside him, crying in a way I told him was happiness, and that was, in fact, considerably more complicated than that. He never saw the house finish the renovations we'd planned together. The new plumbing, the restored piazza railings, the kitchen we'd sketched out on a napkin one night, half joking, half serious, about what we'd do someday when the money allowed for it. I finished that kitchen 4 years after he died, working with a contractor Daniel had actually recommended years earlier for an entirely different project. And I stood in the middle of it the day it was finished, alone, running my hand along the new counter, and let myself cry for exactly as long as I needed to before I picked the children up from school and became, again, the version of myself that doesn't fall apart in front of them. He never saw Sophie's growing obsession with the ocean, an interest that started, as far as I can tell, with a single field trip to the aquarium in third grade, and has since consumed every subsequent birthday request, every summer camp choice, every conversation about what she wants to study in college. I think about how much he would have loved watching that particular passion develop. Daniel, who designed buildings meant to withstand hurricanes and flooding along a coastline he loved with a specific, protective ferocity, would have found something almost poetic in his daughter wanting to study the water directly rather than merely building around it. I don't share these memories, these specific absences, to wallow in them, though I understand if they read that way. I share them because I think grief, told honestly, has to include this dimension, not just the sharp, dramatic loss of the funeral and the immediate aftermath, but the long, quiet accumulation of smaller losses that never stop arriving, years later in the middle of ordinary Tuesday afternoons, when your daughter does something so specifically, unmistakably her father's, that the loss reintroduces itself all over again, as fresh as the night the state trooper stood on my porch. I have learned to let those moments happen without trying to outrun them. I used to think grief was something you moved through and eventually left behind, a phase with an endpoint. I've come to believe, instead, that it's more like a room in a house you continue to live in. A room you don't spend all your time in anymore. A room that doesn't dominate the floor plan the way it once did, but a room that's always there, always part of the structure, and that you learn, eventually, to walk past without flinching, and occasionally to step back into, on purpose, when you need to remember something you're afraid of forgetting. Every March, on the anniversary of Daniel's death, I do the same small ritual, one I developed almost by accident in the first year, and have kept, deliberately, every year since. I take the children to the pier at Folly Beach, the same pier where Daniel proposed, all those years ago, with his grandmother's ring and a nervousness he later admitted had kept him awake most of the previous night. And we walk out to the end of it together, just the three of us, and we each say one thing we remember about him that year. One specific memory, not a general sentiment, but something concrete and particular. The first year, Sophie, only 8, said she remembered the way he used to let her help him draw building plans, handing her a ruler and letting her add lines to blueprints that, she now understands, he probably had to quietly correct later without ever telling her. Noah, not yet 3, mostly just repeated Sophie's memory back with slight variations, too young to have real memories of his own yet, a fact that used to make me ache with a particular sadness, that my son would grow up knowing his father almost entirely through other people's stories rather than his own direct experience. That's changed, gradually, as Noah's gotten older and started asking his own questions, building his own relationship with a father he barely got to know directly. Last year, at 12, he said he remembered, or thought he remembered, he was careful to specify, not sure if it was a real memory or a story he'd absorbed so many times it had started to feel like one. The specific weight of being carried on Daniel's shoulders during a 4th of July fireworks display downtown, high enough to see over the crowd, secure in a way he described as, like nothing could ever actually go wrong from up there. I have my own memory each year, different every time, chosen from an enormous permanent archive that doesn't diminish no matter how many years pass. Sometimes something significant, like the rainy afternoon we met in that coffee shop on King Street, and sometimes something almost absurdly small, like the specific off-key way he hummed while making coffee. A detail I mentioned earlier in this telling and that I return to, on the pier, more often than almost any other memory, because it captures something essential about him that the bigger, more dramatic memories somehow don't. He was, underneath everything else, an ordinary, happy man, humming badly in his own kitchen, entirely unaware that anyone was listening, entirely unaware of how much I would eventually miss that specific, unremarkable sound. This past March, the 8th anniversary, Sophie added something new to the ritual, without any prompting from me. After we'd each shared our memory, she said quietly, looking out at the water, "I think Grandpa Robert would be really proud of how this all turned out. Not just the house. All of it. You and us. And even Grandma Diane. A little bit, even though she messed up really badly." She looked at me. "Is that a weird thing to think?" "No," I told her, and meant it completely. "I think about that exact thing more than you'd probably guess." We stood on that pier a while longer, the three of us, watching the tide come in, before we walked back to the car and went home to the house that Robert Whitfield's quiet, patient foresight had ultimately protected. The house Diane Whitfield laughed about signing away, in a courtroom on a gray Tuesday in October, never once suspecting that the very fine print she dismissed without reading would be the thing that made sure she never actually won at all. If you've read this far, there's a decent chance you're not reading this story out of idle curiosity. Maybe you're in the middle of something that rhymes with this. A mother-in-law who has never once seen you as truly family. A legal fight over money or property that feels impossible to win. A grief that's being exploited by someone who should be helping you carry it instead. I want to speak directly to you, for a moment, before I close this out completely, because I remember exactly what it felt like to search for stories like this one during the worst stretch of my life, hunting for some proof that people survive things like this, that the fight is winnable, that I wasn't foolish for refusing to simply give up. I want to tell you plainly, you are not foolish for fighting. You are not ungrateful or difficult or dramatic for refusing to hand over what's rightfully yours simply because the person demanding it has more confidence, more money, or more years of practice manipulating a family's sense of obligation than you do. Confidence is not the same thing as being right. I cannot say that enough times in this telling, because it was the single most important thing I had to unlearn about how power actually works inside families. That the person who sounds most certain in the room is not necessarily the person who has actually read the fine print correctly, and that your own quiet, careful diligence is worth more, in the long run, than anyone else's loud certainty. I also want to say something that might be less comforting. Not every story like this ends the way mine did. I got lucky in a specific, meaningful way. Robert Whitfield's foresight, Harold Voss's integrity, Monica Reyes's willingness to fight for a stranger she met at a spin class. Not everyone facing a fight like this has a hidden memorandum waiting to be discovered, or a friend with exactly the right expertise willing to donate months of unpaid work to their cause. I don't want to pretend this story is a template anyone can simply follow to guarantee their own victory. What I do believe, though, is that the underlying principles hold regardless of the specific mechanics available to you. Document everything, read everything, trust cautiously, ask for help earlier than your pride wants to allow, and never let grief convince you that you don't deserve to fight for what's yours, simply because fighting feels exhausting on top of everything else you're already carrying. I think, too, about the version of this story from Diane's side, because I've tried, over the years, to hold some complexity about her rather than flattening her into a cartoon. She was, in her own understanding of events, protecting her grandchildren's inheritance from a daughter-in-law she had never fully trusted, not because I'd ever given her genuine reason not to, but because trust, for Diane, had always been a scarce resource she doled out based on bloodline and pedigree rather than actual character or actual love. I don't think she woke up one day and decided to become a villain. I think she spent decades building a worldview in which control equaled love and certainty equaled correctness. And by the time that worldview finally collided with consequences serious enough to challenge it, she was 70 years old and profoundly unpracticed at examining herself honestly. I say this not to excuse what she did. She absolutely deserved every consequence that followed from it. But because I think there's a lesson buried in her failure that's worth carrying forward separately from the triumph of my own outcome. Don't let yourself become a person who mistakes certainty for correctness, who stops reading carefully because you've decided you already know the answer. That mistake cost Diane everything that mattered to her. Eventually. I'd rather learn from her downfall than simply celebrate it. To anyone currently sitting where I once sat, at that kitchen table, staring at a certified letter you weren't ready to open, or across a table from a lawyer telling you settlement is your only reasonable option, or on a courthouse bench waiting for a hearing you're not sure you have the strength to survive. I don't know the specific shape your fight will take, or whether you have a Monica waiting to be found, or a memorandum buried somewhere in a fireproof box you haven't opened in years. But I know this much, because I lived it, minute by exhausting minute, for a year and a half that felt, at the time, like it might never end. You are allowed to grieve and fight simultaneously. You are allowed to perform calm you don't feel, while quietly building the case that will eventually prove you right. You are allowed to sign something that looks, on its face, like total defeat, and still, underneath that signature, be exactly 3 steps ahead of the person laughing behind you. Diane Whitfield laughed in that courtroom because she believed she'd finally won. She never read what was buried in the fine print. I did. And whatever fight you're in the middle of right now, whatever fine print someone is hoping you never bother to check, I hope sincerely that you read it too, all the way to the very end, the way I finally learned to. I am sitting on the front porch of the Trad Street house as I finish writing this, the same porch where Monica once walked me through the plan the night before that courtroom hearing, the same porch Daniel and I sanded and repainted together, one slow spring, more than a decade ago. The heart pine floors inside still grown in all the same places. The azaleas Diane once had a landscaping crew fix, without my permission, have long since been replaced with whatever I wanted, which turned out to be something considerably wilder and less manicured than Diane would have ever approved of, and which I love precisely because it's mine. Sophie is 15 now, applying to marine biology summer programs with the same ferocious focus she's brought to everything since she was small. Noah, 12, has given up on pitching entirely in favor of catching, a position, he informed me solemnly last season, that actually requires thinking, a sentiment I found both hilarious and, coming from him, entirely unsurprising. I think often about that morning in the courtroom, about the particular sound Diane made when she believed she'd won, about the 25 minutes that felt like several lifetimes, about signing my name to a document that appeared, on its face, to end everything I'd spent 11 years building. I think about how close I came, in the exhausted early months of that fight, to simply believing Preston Hale, to giving up the fight before Monica ever found the memorandum, to signing away my home in the ordinary, unremarkable way rather than the elaborate, secret way that ultimately protected it. I don't know what would have happened in that version of my life, the one where nobody finds book 4471, page 209, where the house genuinely transfers into a trust Diane genuinely controls, where I move my children into some smaller rental across town and start over from considerably less ground than I'd had before. I don't spend much time imagining it anymore, though I did, for years, in the specific insomniac hours after midnight when the mind insists on rehearsing every disaster it managed to avoid. What I know instead, sitting on this porch, in this house, watching my children grow into people their father would recognize immediately and be immeasurably proud of, is this. Diane Whitfield laughed in that courtroom because she believed the paper in front of me said what she wanted it to say. She never read what was actually buried inside it. Not carefully, not completely, not with the kind of attention that might have saved her from the very outcome she was so certain she'd secured. She trusted her own certainty more than she trusted the actual words on the page, and that particular trust, more than any single legal argument Monica ever made, was the thing that ultimately undid her. I have tried, in the years since, to hold on to the opposite instinct, to read carefully, to trust cautiously, to never again assume that confidence and correctness are the same quality in a person, myself included. It has made me, I think, a better mother, a better nurse, a better friend, and certainly a far more careful reader of anything anyone ever asks me to sign. It cost me more than I can easily measure, a year and a half of my life, a version of trust in my late husband's family I will never fully recover, sleepless nights I wouldn't wish on anyone. But it also gave me something I don't think I could have found any other way, an unshakable, hard-won certainty in exactly what I am capable of protecting, and exactly how far I am willing to go to protect it, when the people I love most in the world are the ones at stake. Diane laughed in that courtroom. She never read what was buried in the fine print. I did. And that, in the end, made all the difference. The end.